All right, good morning, everyone. We are reconvening the Corporation of Hamilton against the Attorney General. The appearances are as before. My Lord President.
Well, good morning, everybody.
Morning.
We have received very recently, understandably, the supplemental notes, and we may need to be taken through those by both sides, since the time available to read them has been extremely limited. Right, Sir Jeffrey.
My Lord, yes, we have handed up the appellant's note on expression, and I would be grateful for the opportunity to take the court through that. I've just received about 5 minutes ago the closing submissions of the respondent, and I've speed read them, it seems what he is saying is that, in fact, he agrees with my interpretation of Section 7AA of the Municipalities Act, in that it does not permit the minister to expand the powers of the corporation. He distinguishes, and he must say,
I mean, forgive me. Could we take things in some form of order?
yes.
No, just listen to me. We were in the middle of dealing with your submissions on protection of law and the rule of law.
Yes.
It would be very convenient to me if we could continue where we left off and then come back to the separate subject, which is the subject of the supplemental submissions.
Yes, my Lord, I only raised it because he implies that in pursuing my argument, I'm pursuing an argument with which he agrees. But I would prefer, and I accept your invitation to do precisely that. Well,
let's do what I want and you would prefer.
Yes, I entirely accept that. Absolutely. I think we were up to paragraph 4 of my submission.
Yes, we were.
And I raised the question that you, my Lord, had raised earlier. What's the point of this? What's the point of this if, as my learned friend had submitted, if the matter were to be examined in the courts, they would read the provision down so that it's strictly that the minister's instructions and the subsequent action of the corporation strictly conformed with municipal purposes, despite subsection 1 saying that any act or thing done by the corporation shall be deemed to be for municipal purposes. And so you, my Lord, raised the question, what's the point of it? And we submit that it is quite plain that the deemed provision, as we call it, is intended to empower the minister to require the corporation to act outside of its municipal purposes. Now, the respondent then, I'm at paragraph 6 now, the respondent submits that the proper challenge is to the decision of the minister, not of the legislature, to grant him the power in section 7AA. But that doesn't work, we say, because we feel, we believe that the power itself is repugnant to the rule of law and the separation of powers, which I will then go on to argue. And what we say is that it is the grant of the power which is constitutionally offensive and is here properly challenged. So we challenge this provision in its entirety, because we say that the provision itself, irrespective of how it might be implemented at a later date, is constitutionally offensive and is here properly challenged. We say that it is no answer to say that the Assembly has sovereign powers to permit a broader purpose than municipal by means of a deemed provision given to the minister. And we say that this is because the power of the Assembly is constrained expressly or impliedly by Section 1 of the Constitution, by the protection of the law, and if not, inherently by both the principles of the rule of law and the separation of powers. Why the separation of powers? In effect, because we have the executive, the powers given for the executive to change the law, to completely alter the fundamental purpose of the law, and to allow the authority to go outside of municipal purposes. And we do not think it is for the minister to widen the jurisdiction laid down by the legislature. And we say this is a general principle and applies particularly where, as we have said, the power to widen the jurisdiction is conferred on the minister in the same statute, which confers a limited jurisdiction on the corporation. The Bermudan Constitution we submit provides separately for legislative, executive, and judicial power. And as stated by Lord Sumption, I turn to Ferguson and AG, that's at tab 5 at paragraph 14. My Lord, you could, if you wish, to turn to that, to the case. What I will try and do this afternoon in London, morning in Bermuda, is to summarize and, if possible, have before you the relevant passages where possible, or if we read them many times, to refer back to them to avoid delay, if that is your wish. In any event, in Ferguson, at tab 5 at paragraph 4, we have the following, and it is there on on the document that I've submitted. Constitutional instruments, says Lord Sumption, fall to be interpreted in the light of a number of fundamental principles which are commonly left unstated, but are inherent in a democracy and in conventions inherited from the period before they were adopted. One of the fundamental principles of the Constitution is the qualified separation of powers. It is qualified because the Westminster model has never required an absolute institutional separation between the three branches of the state, but the relations between them are subject to restrictions on the use of its constitutional powers by one branch in a manner which interferes with the exercise of their own powers by the others. And this is precisely what's happened here. And after the quote from Hines, the separation between the exercise of judicial and legislative or executive powers has been described as a characteristic feature of democracies. So here we have the statute allowing the minister effectively to undermine the foundational purpose and function of the corporation as laid down in the Municipalities Act. And we say this is a fundamental breach of separation of powers, as defined by Lord Sumption.
Yeah.
So we also say that it is a violation of the rule of law, even in countries without a written constitution, like the United Kingdom. It has been held that the rule of law forbids the legislature from precluding challenge by way of judicial review of a decision of a body which is said to have exceeded its jurisdiction. My Lord, we considered that question last evening. It has to do, of course, with the ouster clauses. And this is because the rule of law requires, firstly, access to justice to challenge any unlawfulness on the part of a public body. And secondly, and this is important in this case, the boundaries of the jurisdiction conferred on the body by the legislature must be honored, and they must not be open to amendment by a person or a body which is established by that same legislation. And I refer there to Anismetic and Privacy International.
Sorry, can we just work out which bodies we're talking about? The rule of law in this case forbids the legislature from precluding challenge by way of judicial review of a decision of a body, that's presumably in the present case the minister.
No, I'm sorry. I'm drawing an analogy there, which I drew earlier in discussion yesterday between I'm saying the rule of law as an unwritten constitutional principle, even in countries like the UK without a written constitution, forbids the legislature from precluding challenge by way of judicial review of a decision of a body which has exceeded its jurisdiction. That's the ouster clause, which doesn't necessarily apply here. But I'm saying the reason for that, as we considered yesterday, is not only access to justice, but, and here this second rationale for that, in the case of ouster clauses, applies to this situation, is that the boundaries of the jurisdiction conferred on the body by the legislature must be honored. And the boundaries are not being honored because the minister may exceed them, and then they will simply be deemed to be functions and powers of the corporation, despite the legislature requiring it to act within those municipal powers. Now, so I go on to say that
well, wait a minute. So just a moment. So applied to the facts of this case,
yes,
you say in relation to 2 that the boundaries of the jurisdiction conferred on the corporation by the legislature should be honored and not open to amendment by a person, e.g. the minister or body which is established by that same legislation.
yes. Well, in this case, the minister.
Yes. Who's not in fact established under the Municipalities Amendment Act.
Sorry, I didn't catch that fellow.
The minister is not established under the amendments, the Municipalities Act, is he?
No.
No.
So I say that both those ingredients of the rule of law apply. Access to justice to an extent as well, to this extent, that the deeming clause, I would say, is completely is completely devoid of ambiguity, and therefore, if the corporation does go outside its powers, I feel that there is no acting under when the minister acts under a deemed power. There is no reasonable prospect of the courts holding that power to be ultra vires, because the deemed clause deems it to be intra vires. So access to justice comes into it, but mostly important, any challenge to an excess of jurisdiction will be met with a reliance on the minister's deeming power. And so we say both rule of law in that respect, and also the breach of the separation of powers, because the law has the feature of permitting an excess of jurisdiction under a statute by ministerial fiat. So the rule of linking the rule of law prohibition with that of the separation of powers. Now, my lord, my learned friend took us through the Pearson case yesterday. It's contained in his second submissions. We did look at that yesterday, and I think for us very helpfully, he asked us to look at page 32 of that case.
Where do we find the Pearson case?
It is contained in his submissions. I do not have a tab number for it. Could he help us, please, on that?
His submissions in relation to the rule of law argument.
Yeah, they were supplied with the argument itself, so they weren't part of a binder with a tab.
But I think they did reach the cloud eventually, didn't they?
I think Mr. Coelho confirmed that yesterday.
Good. I would like to just look at that case very briefly.
Paragraph 22 of the respondent's submissions.
In the respondent's submission. That's where my copy isn't there. I'm sorry, I haven't seen it in the chat. I do have it in
Sorry,
tab one.
under which heading is it?
This is
Which
the,
heading on the cloud?
I would be grateful for some guidance on this, Lord.
Can Mr. Coelho help?
I'm sorry, what is the reference?
The references are and Secretary of State for the Home Department, ex parte Pearson.
Just a second.
Oh, I found it now.
It's on the further submissions by Duncan QC 2021-11-10.
Oh, it's the fourth one that, it's the fourth one down. Oh no, when I try and open it on the cloud, it isn't there. I'm afraid this keeps on happening. It appears to be a PDF there. You click on the cloud and the PDF disappears.
Is it the fourth one down or the fifth one down? I don't have it on the fourth one down.
No, wait a minute. Sorry, it's the third one down.
If it assists the court, I can bring it up on the screen.
My Lord, I can easily, the words were read out, some of the words were read out yesterday by my learned friend. And I just like perhaps very quickly to point to another paragraph. I can.
Sorry, Coelho, could you give me what is the tab it's under? Is it further submissions by Duncan QC?
Yes,
Well, there are two of those.
Oh, right.
2021-11-10.
Yeah.
And then Pearson appears, I think the third one down.
I don't know if
I've got it. I've got it. Thank you.
I don't know if it helps members of the panel, but the case was attached to the rule of what I've called the rule of law submissions.
It doesn't help, Mr. Duncan, because we're trying to find it on the cloud. There are frankly so many bits of paper, and if you send in submissions with cases attached by email and they're not on the cloud, it does become very difficult.
It is on the cloud for my colleagues, but it's come off the cloud for me.
And I haven't yet been able to find it on the cloud. And I wonder if Mr. Coelho can just go through.
I can, Professor Jewell, if you give me the page number of the authority that you're referring to, I can bring it up on the screen.
Thank you. Thank you. It's page 32 and then page 34. Those are the only pages I need.
So page 32. and 34. Okay,
Oh, excellent. Thank you.
and can you identify the paragraph?
Um, in the Thomson's Reuters case that you sent, there doesn't seem to be a paragraph number, but I will, on page 32, it's the third paragraph, beginning, but it is to Sir Rupert Cross that I turn.
Right.
Right.
Or just before that, he refers to Dicey, who is cited in some cases, and explains the context in which Parliament legislates. And even Dicey says, every path we come around to the same conclusion that parliamentary sovereignty has favored the rule of law, and that the supremacy of the law of the land both calls for the exertion of parliamentary sovereignty and leads to its being exercised in a spirit of legality. And what Lord Steyn and Lord Brown Wilkinson, who incidentally was in dissent in this case, had to do with the retrospective raising of a prisoner's sentence. What he seeks to do is to discover whether there are inherent in the common law constitutional principles. And if we go down that page, we see, he draws on Sir Rupert Cross, who expands on the notion of legality, which initially comes from Dicey, that I've just read out, the spirit of legality. And he says, this is Rupert Cross, and as my friend read this paragraph yesterday, statutes often go into considerably detail, but even so, allowance must be made for the fact that they are not enacted in a vacuum. I won't read the rest of that paragraph because it was read out yesterday, but I would like to read simply the last sentence, namely that there are principles, and they operate here as constitutional principles that are not easily displaced by a statutory text. So what I'm arguing here, and what Lord Steyn and Lord Brown Wilkinson, Lord Steyn for the majority, argued in the case of Pearson, was that it was simply almost for the first time then, in 1998, in our common law, explicitly recognized what are now called common law constitutional principles. The point, of course, is that if they exist in the actual Westminster Constitution, they surely also exist in a constitution such as Bermuda's, and even more so in the sense that there is reference to protection of the law, and all the more so because it is a limited constitution, limited by rights, and we would also say by fundamental constitutional principles, which apply in this case in two respects. Well, it's in the respects that I've mentioned. If we could turn now to paragraph 30, page 34. Again, this is in paragraph 3. Lord Steyn says there, I'll take you to the very last but one and last sentence. Unless there is clearest provision to the contrary, Parliament must be presumed not to legislate contrary to the rule of law, and the rule of law enforces minimum standards of fairness, both substantive and procedural. I therefore approach the problem in the present case on this basis. I stress that because in the court below, the protection of law and the rule of law was defined simply in procedural terms. In other words, due process, giving people a fair trial. We say that it is wider than that and covers a situation such as this in the way that I have already described. Well, that is all I have from this case. it is.
So Jeffrey, before you move on to a different subject, and just taking you back to the note on the protection of the law and the rule of law, in paragraph 6, you referred to the minister deciding for himself what powers to arrogate to a body he controls. And you'll recall that yesterday, Mr. Duncan took exception to it being suggested that the minister controlled his appointees in any way, and that these would no doubt exercise independent thought. I wonder if you've got any comments on that.
Indeed, I do. I would think that there is intense control at every aspect. I mean, I think the actual the bill has been analysed, and I would totally support the various phrases that were used yesterday to describe it. I believe there is significant, highly significant, if not total control, but over the body, over the corporation in many respects, in respects of management control, in respect of the elections, and in respects of having to verify and approve and sanction every single resolution. I mean, this is significant control.
Well, can you just, that's very helpful, but can you just help me on this? I quite follow everything that you say, and you may be right, that what this rule purports to do is to deem that something is constitutional, and deem means deem, and that's that. It's conclusively deemed. Just pause for a moment and assume that that's not right. Assume that the deeming power is not a power which enables the minister to do anything which is not already municipal, or alternatively, that what he orders is deemed to be municipal, but not conclusively, and it's open to the court to rule that what he has ordered to be done is not valid because what he has ordered to be done is not in fact municipal. Assume either of those sets of circumstances. In that context, that is to say, that the minister's order is not the last word, and can be reviewed by the court, which can, if necessary, say that the order is void. In that context, if it arises, what then is the significance, if any, that if the reform bill is passed, the council, whilst theoretically able to challenge the order of the minister, might be thought unlikely to do so, to put it no higher, because its members will be either appointed by the minister or by a body which he himself has appointed.
My lord, I followed you absolutely up to the last point on the reform bill. I'd be very grateful for you to repeat that.
The reform bill provides that, if passed, provides that in future, the council will not be elected, but will consist in part of persons nominated by the minister directly, and in part by a corporation whose members are themselves, a body whose members are themselves nominated by the minister. What I'm trying to shorten what I had said rather laboriously before, assume, contrary to your submissions, that in fact a decision of the minister could be attacked on the grounds that he hadn't got power to order something to be done which wasn't municipal. Assume that. What in that set of circumstances would the significance, if any, be that although it was possible for the council to bring a claim against the minister that what he had done was void because he had deemed something to be municipal or ordered something to be done which was not municipal, what in that context would be the significance, if any, of the fact that the likelihood of the council making such a claim against the minister would be either unlikely or remote, if that's true, because the council is the appointee of the minister or a body appointed by the minister.
Yes, the council is likely, being realistic, to support the minister, assuming that the deemed power that the minister then seeks to exercise is willingly carried out by the council. And that let us assuming, I'm assuming too, that the deemed power is outside what is now known as municipal purposes. What happens then? A member of the public perhaps could seek to challenge the vires, and if you say it is open to challenge, then it is a matter for the courts to decide the question, to decide the scope of the minister's power. Have I misunderstood the point?
No. What I'm getting to is this. It is said that a corporation appointed in the way that is intended under the bill is unlikely to challenge the minister. Put at its highest, it said that to use the expressions, the corporation will be the lackey or the puppet of the minister.
Yes.
Put less strongly, that in practice, it's likely not to challenge the minister. The position may be that the correct analysis may be that an order that is given by the minister, which is deemed to be municipal, can in fact be challenged in law by a claim for judicial review on the grounds that what the minister has ordered to be done is not municipal.
Yes.
If that is the position, that a challenge can be brought, that would appear to have the consequence that section doesn't have the offensive characteristics that you mention, because it's perfectly possible to challenge it on the grounds that the order was invalid. If that is the case, does it make any difference that the likelihood of challenge is much reduced if the corporation is a body effectively appointed by the minister?
I would answer it in this way. I think it's because if the corporation were to be appointed effectively by the minister, it is more likely that the corporation would itself accede to the minister's instructions.
Yeah.
It is therefore probable, there are always rogue councillors, but the corporation as a whole would be likely to implement the minister's instructions. If someone, on the assumption that it is challengeable in law, then the fact that I think the appointment process may not be relevant to that, because it would be up to probably someone outside of the council to make the challenge. If it indeed were under your hypothetical challenge of bill, then the normal judicial review processes would be in place.
Right.
I would then say, sorry if I'm going on too long on this, but I would then say that fundamental to any challenge would be a challenge that to use the terms of the famous Hadfield case, which says ultimately in challenging an organization's lawfulness, you've got to look to the objects and purposes of the act. And in this case, since anything done by the corporation in pursuance of the minister's directions shall be deemed to be for municipal purposes, I think, I'll come back to the point I made, it's not quite the question you asked, I'm slightly straying, but are doomed to failure, because the deemed power effectively says that the basic foundation of the statute, namely its purposes, can be altered by ministerial fiat.
Right.
Even if there were a challenge, but that's true.
Yes, you say the challenge is doomed to failure because of the deeming provision.
Yes, it is as broad as you can possibly get.
Yes, okay. Okay, thank you.
Thank you. I was going to refer very quickly to Lord Hoffman's now famous passage in the case of ex parte Sims, where this is at tab 51. You can just look at that very quickly. Tab 51 at page, that should be 341. So that's tab 51 at page 341, F and H. He says this, that parliamentary sovereignty that means that Parliament can, if it chooses.
I'm so sorry, which page was it? Which page was it?
Page 341.
Thank you.
341, E to H.
Right.
F to H.
F to H, thank you.
Parliamentary sovereignty. This was a case about freedom of expression. Some prisoners asked to have access to the media to complain about their conditions. And the minister said no under his powers and claimed parliamentary sovereignty. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act will not detract from this power. The constraints upon its exercise by Parliament are ultimately political, not legal. And this was a point that was made yesterday by my learned friend, saying all this is politics, and the Chief Justice in effect said that as well. We don't want to get involved in politics. But then Lord Hoffman goes on, but the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there's too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language, or even the most general words were intended to be the subject in the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. In this way, the courts of the United Kingdom, though acknowledging the sovereignty of Parliament, apply principles of constitutionality little different from those which exist in countries where the power of the legislature is expressly limited by a constitutional document. So here again, saying that there are constitutional principles that inhere, in effect, in a democratic in a society, even though it is not expressly limited by a constitutional document. And that point is also made in the case of Miller. Of course, it's made in at the bottom of my page 4 of my submission. Lady Hale in Jamaicans for Justice. These are, in any event, fundamental common law principles governing the exercise of public functions, irrespective of whether they or not have a status of a constitutional right. As I said when we considered this, she's clearly saying here that these rights, whether they're common law rights or constitutional rights, they equally apply, and this applies to legislation too, and to actions of the executive as well. And I would like to show my lords the case of Miller number 2, which is tab 41. Sorry, tab 31. I'm so sorry.
31. Thank you.
31. Tab 31. Paragraph 39 to 41. In 39, she says, although the United Kingdom.
Sorry, forgive me. I need to find it.
Paragraph 39, you say?
Paragraphs 39 to, yes, 39.
Yes.
Although the United Kingdom does not have a single document entitled the Constitution, it nevertheless possesses a constitution established over the course of our history by common law. I should have said this is a unanimous judgment, as you will know, of the Supreme Court in relation to the prorogation of Parliament by the Prime Minister. So it nevertheless possesses a constitution established over the course of our history by common law, statutes, conventions, and practice. Since it has not been codified, it has developed pragmatically and remains sufficiently flexible to be capable of further development. Nevertheless, it includes numerous principles of law which are enforceable by the courts in the same way as other legal principles. In giving them effect, the courts have the responsibility of upholding the values and principles of our Constitution and making them effective. It is their particular responsibility to determine the legal limits of the powers conferred on each branch of government and to decide whether any exercise of power is transgressed those limited. The courts cannot shirk that responsibility merely on the grounds that the question raised is political internal context. And the last two sentences show that this applies also impliedly to the responsibility of each branch of government, which speaks to the notion of separation of powers. And secondly, even though the matter may have a political impact, the courts should not necessarily shirk that responsibility merely on the ground that the question raised is political in tone or context, which applies foursquare in response to what my learned friend said yesterday. It then goes on to say that the legal principles of the Constitution are not confined to statutory rules, but include constitutional principles. There we have it again, developed by the common law. We have already given two examples of such principles. Namely, the law of the land cannot be altered except by in accordance with an act of Parliament, and that the government cannot search private premises without lawful authority. And the first of those examples has some resonance in this case. Many more examples could be given. Such principles are not confined to the protection of individual rights, but include principles concerning the conduct of public bodies and the relationships between them. For example, they include the principle that justice must be administered in public and the principles of the separation of powers, there we have it again, between the executive, parliament, and the courts. In their application to the exercise of powers, constitutional principles do not apply only to powers conferred by statute, also to extend to prerogative powers, of course, in that case. For example, they include the principle that the executive cannot exercise prerogative powers so as to deprive people of their property without the payment of compensation. And that line, of course, I mentioned it earlier. It has resonance in relation to this case as well. That's all I want to turn up on this point. Except to mention that in Lewis and Attorney General, and this was read at the time, and I need not go back to it, it's at tab 35, protection of the law is recognized in the Constitution of Jamaica and is to be found in the common law, inhering in the Constitution, and this is what we contend for here. So in the light of that authority, and in the light of my submissions, we submit that the absence of a specific right from the Constitution, even if the Section 1 is regarded as not applying in this case, we contend firmly that it does. What else is it there for? It is surely fatal to that will not be fatal to our case, and is wrong because these principles inhere in a democratic constitution such as Bermuda's. And then finally, at paragraph 13, we reject the suggestion that there is a similarity between the deeming clause here, the point that was raised by my learned friend, and the power for a minister to make a factual determination of who is an ordinary resident of Bermuda, the case that he put before us. That is an ordinary fact-finding discretion. That's all it is. And I would say, I said here rather clumsily, they exist all over the law. Well, they do. They're very common. But that's not this case. This case is one when the minister has not the power to make a decision, but the power to decide whether a body which he controls has the power to act in a particular way, and indeed to act in excess of its very jurisdiction, the foundation of its being, and able to do that simply because the power is considered to be deemed. The only other point I should add here is that my learned friend tried to soften the exercise of the minister's huge discretion in this case by saying that there will be consultation. And I think I could deal with this rather quickly by simply saying the final decision will still be with the minister. So, my Lord, that concludes my submissions.
Yes, just before, can we go back to paragraph 6 of your submissions? You say the respondents also submit that the proper challenge is to the decision of the minister, not of the legislature, to grant him the power in section 7AA, but that doesn't work in circumstances where the power itself is repugnant to the rule of law and the separation of powers. If this law is valid, the minister will be acting lawfully in a formal sense when he decides for himself what powers to arrogate to a body he controls. In those circumstances, it's the grant of that power which is constitutionally offensive and is here properly challenged. Now, the grant of the power is said to be, as I understand it, constitutionally offensive because it is for the legislature to determine whether or not to increase or alter the powers of the municipalities. That's the constitutional position. Is that right?
Yes, that's the one point. Yes. The other, please.
But could it be said that the legislature has decided how to amend the powers by saying that the corporation shall have such powers as, in effect, the minister gives to them.
Well, let me answer that in two. I answer that, my lord, in the next paragraph. It is no answer to say that the Assembly has sovereign power to permit a broader purpose than municipal by means of the deemed power provision. This is because the power of the Assembly in Bermuda is constrained expressly or partly under Section 1 of the Constitution by the protection of the law. So it itself cannot do that. Because to arrogate that kind of power would be to breach the rule of law and the separation of powers. That's essentially my position. In the same way, by analogy, it could be said that even though the legislature provides for an ouster clause, does not necessarily mean that ouster clause can have any effect under the rule of law. Because this is a sort of sidewind challenge to supremacy of Parliament by asserting that the Constitution in this case is supreme. The Constitution deeply embeds the notion of rule of law and separation of powers. So the legislature is constrained by the Constitution in a constitutional democracy, which this is.
Well, going on in paragraph 8, you say, in respect to the separation of powers, it is not for the minister to widen the jurisdiction laid down by the legislature.
Yes, well, that's my second point.
Well, wait a minute.
Yeah.
But if the position is that the legislature says, in effect, the municipality shall have power to do anything that the minister orders it to do, isn't it the legislature that has widened the jurisdiction laid down previously?
No, it hasn't widened that jurisdiction. The jurisdiction stands. The jurisdiction is clear, municipal purposes. It is saying, you minister may widen the jurisdiction if you wish. And if you do so, it will be deemed to be so. It is for you to do this. Outside of the legislative competence, we are delegating this legislative competence, in effect, to a minister.
Yeah,
and this is what we say offends the separation of powers and the rule of law.
Yeah, okay, thank you.
Lords, if there are no further questions on this, I would turn to the issue of expression.
Yes.
And I hope you will have received my note on expression that I sent earlier today.
Yes.
I will then proceed to go through that again as speedily as I may.
So Geoffrey, I don't want to take you out of your order, but what do you say about the status point? How are we going to deal with that?
Are you referring to standing to sue? Or?
Yeah. I mean, it's just my preliminary view is that the freedom of expression point is better raised by a ratepayer or an elector rather than the corporation itself. And that could be overcome simply by having Mr. Gosling or someone else as a party to the appeal. What is your basic submission on that?
My submission is the one I made on the first day, which is, first of all, the corporation has already been accorded standing to sue in this case. Here we are.
Well, just a second. You've been afforded standing to sue, but at the time you were afforded standing to sue, you hadn't raised the Section 9 point.
But a number of other points which contain deeply that point, which has not been brought up before, and about which we gave notice on the 20th of August. My learned friends is implying that we only told them recently about this, and they responded in their skeleton argument, incidentally. This point has been before you since the 20th of August, but we felt it right, however, nevertheless, to make a formal application through a summons to bring this point, because it isn't.
My Lord, I will be discourteous once and just say that in the skeleton argument, we took the standing point. The skeleton argument. Thank you.
Thank you. Not at all discourteous, very helpful. Thank you. Secondly, Section 1 of the Municipalities Act in 1923 says the Corporation of Hamilton means the mayor and councillors of the city of Hamilton. And it is those offices that will be terminated. The present officers will lose their seats, as it were.
Sorry, I don't. Why are you cavilling from the point that it's only a procedural point and one can just add a party who is a voter?
Well,
I mean, it's the freedom to vote, isn't it? I mean, as I understand your submissions.
yes.
And the
yes.
people who are elected, okay, they may vote for themselves, but they're not actually there in their capacity as voters. Or are they? Are you saying that?
Well, some of them, I'm sure that all or many, or if not all of them, are actual electors in Hamilton. I don't know, but I suspect that may be so. Secondly, they represent, they can act for, they can stand in this case, in a representative capacity, surely, and they're willing to do so, and have said they're willing to, they've agreed to do so. And we are here, and I just make a third point in a moment, but in between those points, interstitially, I would say it would be, I would submit that it would be disappointing is perhaps too low a word, but for this court to not deal with all the constitutional points that underlie this matter at the same time, simply because they all hang together in an important way. It just seems.
Yeah, I see that, but why are you cavilling at the notion that one could join a voter in a representative capacity? Because
my lady, if it assists, may I just interrupt just 1 second? I don't mean to.
That's a matter for the president, but please, as far as I'm concerned, please do.
I'm sorry.
Yes, what do you want to say?
This, that our instructions are that the mayor is quite happy to be joined to deal with the procedural issue as an elector. Just to deal with.
That's what I wanted to know. Thank you very much.
Thank you, my lady.
Yep. Okay. Right.
I did not know that. I'm so sorry I wasn't aware of that, but I'm pleased.
I've just learned that, my lady.
Yes. Okay. That solves that problem. Now, where do we go from there?
Okay.
Could I just ask Mr. Myers? I mean, that presupposes that the mayor is an elector, which I presume to be the case.
That is the case.
Yeah.
Yes.
Thank you. Hello. Thank you.
Can I just ask, is anything, I mean, are we going to see anything in support of this, or is it just that the court is taking it de bene esse? How is it being dealt with so that I can address it with my clients?
Well, I think you should assume, okay, I think you should assume that the minister, the mayor, applies to be joined in his capacity as an elector, and that we are minded to allow that to take place.
My Lord, will there be any evidence filed in support of that? I don't know if he's an elector. I don't know what his position is.
It just goes to the point of standing.
No, I was making a slightly different point. I don't know whether or not he is or isn't. Normally there would be, for the purposes of the Act, there has to be certain formal requirements to establish that you're an elector.
Yeah, but let's come, I'm sorry.
Well, can't we have a statement from him which simply says, I am the mayor, paragraph 1, paragraph 2, I am an elector of the municipality?
I will look at the Act because there are certain provisions under the Act that have to be complied with. Having been an elector myself, I'm aware of them. So I will look under the Act and just make
I'm sure the mayor's aware of them too.
Sorry, there are certain, start again. There are certain provisions that have to be complied with in order to do what?
To vote.
To be an elector.
To be an elector, yes. So I mean, if the court is saying that it's going to disregard them, I just know that there are certain provisions. Because as I said, I was an elector.
No, we're not saying that. Nobody said that.
It appeared, I'm sorry, perhaps we've taken things too swiftly, but it appeared to me that if the mayor was prepared to be joined and said that he was an elector, the overwhelming likelihood is that he is an elector. But if you want a statement from the mayor, I am happy to be joined and I am an elector.
That can be supplied,
that can be arranged. If you then, having assumed that you've got that statement, and we won't proceed, I think, without it. You need to tell us then if you want to say that although the mayor says he's an elector, he isn't an elector.
Thank you.
Right.
My Lord, going to my note, I've set out the Constitution and the parallel Article 10 of the European Convention on Human Rights in paragraphs 1 and 2 respectively. Section 9 of the Constitution provides, except with his consent, no person shall be hindered in the enjoyment of his freedom of expression. As opposed to, on the next page, paragraph 2 of the European Convention, interestingly, everyone has the right to freedom of expression. They both provide freedom of expression, The Bermudan provision provides more in the way of perhaps an obligation of the government and the right to an enjoyment of freedom of expression, whereas the ECHR is more directly set out as in the nature of a right. And then when we look to the limitation clauses, we see that the under subsection 2, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question makes provision that is reasonably required in the defense of the various limitations. We've discussed public order because my learned friend did in his first skeleton argument reply that I referred to a moment ago. He did raise the question of public order. We say public order doesn't apply. I'll come to that point. And then again, he said yesterday, the limitation of, for the purpose of protecting the rights, reputations, and freedoms of other persons or the private lives of persons in legal proceedings. And I'll come to those limitations in a moment. They're somewhat different from the limitations that are provided under Article 10 that we see on paragraph 2 under subsection 2 of Article 10. But if I may turn now to paragraph 3, the corporation is a local government entity which has been run on democratic lines for about 300 years. It is still so run, with qualified electors possessing a statutory right to vote in regular elections. This reform bill has not yet been passed. So at the moment, the electors of Hamilton do have a right to vote in elections, and it is the deprivation of this right that we are challenging on the ground of a breach of Article 9. And this is the right that is now being threatened because the 2019 bill proposes to disenfranchise the present electors and to replace them with the centrally appointed council that has been called so many different names over the last day. Now, the respondents contend, I set out in paragraph 4, that this is a matter of high social and economic policy, which is really not a matter for this court. I've dealt with that to some extent in some of the submissions that I've just made about rule of law and that have been enunciated by various courts. I clearly, well, I'll come to that in a moment in riposte. They also say that the new arrangement will allow a wider constituency to have a say in the affairs of the corporation. Wider constituency. And they also say, and this was considered in some detail last evening, that there is no right to vote under the Constitution, and therefore no right in issue here. Now, we submit in response to that, firstly, that in a modern rights-based constitutional democracy, the government, of course, has the right to make policy, but, of course they do. And the higher the policy, the more they have the right to make it. But the key, and this is this has come up so often in the context of these measures, this has to be subject to the rights of the individual and the duties of the government, as well as the fundamental principles such as rule of law and separation of powers. And in this case, in here, we say that it comes up against a constitutional principle of free expression, particularly under the Constitution, and that must prevail. It trumps policy in this particular case. We say also that the change to the constitutional system is not the kind of high policy that the courts often feel is the province of courts, of government rather than courts. Utilitarian calculations of the social good on the basis of economic and social factors, questions as to whether to build a new runway on an airport, that kind of thing. This goes to the heart of the institutional character of Bermuda, of its decision-making processes. So this is certainly a matter, but I would urge as a matter for you, my lords, to consider very carefully. And I would also say, and this goes to the point of evidence to a large extent, and this is simply what we're trying to assert, and really doesn't need evidence and is really beyond peradventure of doubt, that the purpose of a series of legislative measures since 2020 has been to subject the corporation to increasing central control. And I won't go again over the statutes. The Chief Justice set them all out very clearly and succinctly. But one by one, they were encroaching on the autonomy of this corporation, one by one, ceaselessly and incrementally. And this latest proposal, I won't go over those measures because I will deal with that later when we talk about actual control. But this latest proposal seeks to ensure that the mayor and council are not directed by or are accountable to the opinions and beliefs of the electors of Hamilton. That's its purpose. That's its purpose. Can't be any other purpose. That's its purpose. And we say that this is a clear hindrance of the expression of the electors and a classic example of suppression of political speech. Now, the Lords, when I say that, so what I'm saying is that in bringing this new point, we will not need any evidence on any aspect of it. We don't need to go to motive. I withdrew that. I was cautious in the submissions that I put in earlier and in the summons, and I apologize if that misled. It was a belts and braces approach, but
or it might be regarded as a touch of hyperbole.
Or a touch of hyperbole. But in the end, we say it's all about control. That has really been the essence and foundation of this whole case. And this is what it's all about. And how else can one explain the series of acts that have imposed that kind of control? And this is I think, the cherry on the top. Bad analogy.
But the suppression of political speech is the vote which says, "I want you to represent me."
Yes. No longer will that be possible
Yeah.
for the inhabitants of the corporation's geographical jurisdiction, and this is serious. This is serious suppression of speech, because they will not be able to express who they want to represent them.
Short but serious.
Yes. In order to add perhaps to some of the hyperbole, but I think it's an important statement because this is in the Toronto case, which I think I had before you on the first day and need not return to. And in any event, my learned friend is returning to it, so I'll give him that privilege. But again, I might have read some of this out earlier, but I think it really is worth looking at, because it was in her dissent, but without demur on the general principle from the majority in the Toronto case. Again, Toronto case is the rejigging of electoral boundaries and an attack on the grounds of free expression. This was simply almost an administrative matter during the course of an election that people were slightly, well, we went through it before. Not nearly as serious as this situation, which actually involves complete disfranchise of the whole community. And she says, elections are to democracy what breathing is to life, and fair elections are what breed life into healthy democracies. They give the public a voice, and that's the point that my Lord has just raised. They give the public a voice into the laws and policies they are governed by, and a chance to choose who will make those laws and policies. It is a process of reciprocal political discourse. I think that's a fine statement and encapsulates entirely what I had said much more clumsily earlier on. And the second paragraph simply says, it goes on in that way and says, the final act of voting itself a form of political expression. The final act of voting, that's the second sentence, itself a form of political expression, is the culmination of the process of deliberate engagement throughout an election period. The stability of an electoral process is therefore crucial not only to political legitimacy, but also to the rights of candidates and voters to meaningfully engage in the political discourse necessary for voters to cast an informed vote and for those elected to govern in response to the expressed views of the electorate. And that is why this issue of simply abolishing the elections, creating a system, basically a appointed system by the executive, in effect, is so fundamentally serious. It may or may not be within the power of the government to do. What I am saying is that it seriously and fundamentally it amounts to, has the effect of suppressing political expression. Now, I turn in paragraph 7 to the fact that there is no right to vote contained in the Constitution. But we say that does not undermine the appellant's argument. Because, first of all, as I said at the outset of the submission, there is a right to vote under the Municipalities Act, which is being threatened with withdrawal.
Just pausing a moment.
Yes.
Assume that there weren't municipal elections, would it be open to an inhabitant of Hamilton to say, my freedom of expression is hindered because there isn't an election in which I can say who I want to represent me in relation to the affairs of Hamilton?
I would think it would be a hard case to make on that ground, but simply because there is no constitutional right in Bermuda to local government. Had there been a constitutional right to local government, one might have made an argument, well, implied in the notion of local government, and I could make that argument, and I was going to touch on that, implied in the whole notion of a truly local corporation as opposed to a quango, quasi-autonomous non-governmental organization, which has more of an executive status. While it is a municipal body, I think it could be arguable that it was required to respond to the will of the people, both in the election of its members and in terms also of accountability. But I think it is a case that, the more I think about it, it's a case that might be able to be made, depending on the circumstances. Context is all. The context here, my lord, is that for 300 years, people have exercised this right. It wasn't always a perfect franchise, by no means. It's righted itself over the years. But the fact is now that it is a completely democratic system, and that the right is taken away.
Okay, thank you.
I then say it's not a constitutional right. It doesn't have to be, I submit, because its withdrawal engages Section 9. Because its effect is clearly to hinder free expression through the ballot and through elected representatives. And yesterday, I handed up Clayton and Tomlinson, the enormous treatise on law of human rights, still in its 2009 edition, alas, but nevertheless, the paragraph there is absolutely sound. In contrast, dealing here with, by the way, with Article 10, the expression provision that I set out in paragraph 2 of the European Convention on Human Rights, in contrast to the position under some other articles of the Convention, the question as to whether there has been an interference with an Article 10 right that should be, will usually be straightforward. Interferences with the right to freedom of expression can take a wide variety of forms, and the court has generally considered that anything which impedes, sanctions, restricts, or deters expression constitutes an interference. So we say this is an interference, motive irrelevant, res ipsa loquitur in terms of control. And certainly this is removing the election for the reasons that we've seen, impedes sanctions, or certainly impedes, and is an interference with freedom of expression. Secondly, in terms of, is there a right to vote? We say, my lord, this is paragraph 8, that expression rights are not dependent on other rights. By contrast with, for example, Article 14 of the European Convention, which is what's known as a piggyback right or a parasitic right. You will recall it's the right against discrimination, but only discrimination in the exercise of rights. So that is a right that's parasitic on other rights. And we say that even though there's no right to an election, Article 10, as with Article 9 in Bermuda, is a completely freestanding right. It doesn't need to be supported by, to piggyback upon the right to vote. Always we're saying that I think that's an important point, because all we're saying is that there was a right which is being taken away. There is a right that is being taken away, and it is impeding expression, and which is an independently enforceable right. And the classic statement is set out in Handyside. I've got the paragraph there, so I won't ask you to look at it. It's at tab. Oh my word! I'm sorry, I've left out the tab number.
But don't worry, if this is the relevant paragraph.
There it is. The court supervisor. This is one of the earliest cases on particularly political speech. The court's supervisory functions oblige it to pay the utmost attention to the principles characterizing a democratic society. Freedom of expression constitutes one of the essential foundations of such a society, one of the basic conditions for its progress and for the development of paragraph 2, etc. It is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness without which there is no democratic society. This means, among other things, that every formality, condition, restriction, or penalty imposed in the sphere must be proportionate to the legitimate aim pursued. That's the basic factor. And it is, however, the freestanding right which must be read in proper democratic context, which is dealt with in the case that I think I put before you. I think this is worth reading again, of Bowman and the United Kingdom. Again, sorry, the time this was done, I didn't have the tabs before me. But what it says is free elections, and I had brought it up before, free elections and freedom of expression. Free elections, that deals particularly with elections, and freedom of expression, particularly freedom of political debate, together form the bedrock of any democratic system. And that's an important statement. The two rights are interrelated. So they're talking now about the right to free elections and the right to free expression. They're interrelated.
Well, wait a minute. Here, there isn't a right to an election, is there?
No. We're saying, but what this passage I think is helpful for, which shows that they are separate and independent, and they don't necessarily require each other. They are both independent rights. Operate to reinforce each other. For example, as the court has observed in the past, freedom of expression is one of the conditions necessary to ensure the free expression of the opinion of the people in the choice of the legislature. So what it then says, and I rely on that, freedom of expression is one of the conditions necessary to ensure the free expressions of the opinion in the choice of the legislature. So in other words, free expressions has a part, and its own independent part, in ensuring and requiring, in this case, free elections. For this reason, it is particularly important that the period preceding an election, that opinions and information of all kinds are permitted to circulate freely, which has nothing to do with the right.
That's simply saying what might be thought to be clear, that people, newspapers, and others must be able to say whatever they want to say about political parties and political candidates, particularly shortly before an election.
Yes, but indeed, but Lord, it goes further than that, in the sense that it says that it's one of the conditions necessary to ensure the free expression of the people in the choice of the legislature. I would say yes, absolutely, that side of things. But there's another side, which is that the notion of political speech must extend to just put it in the negative, and in the way that it is phrased in the Bermudan Constitution, that no person shall be hindered in the enjoyment of his freedom of expression in the area of elections, in the sense of not being able to, prevented from exercising his free choice in respect of candidates for an election. I think those two I think it in no way dilutes the notion of free expression in
Well,
the
I can see
context.
that you shouldn't be prevented from exercising your free choice of candidates for an election, but that assumes that there is an election. And if the position is that it's for the legislature to determine whether there should be an election, and it decides that there shouldn't, the fact that you would have had freedom of speech if there was an election becomes past history.
My Lord, there is now a right to an election.
And there is now a right to an election.
Right. But the situation here is that the government are seeking to withdraw that right, and to hinder the free, and thereby to hinder the free political expression of the electors of Hamilton.
Because there won't be any electors.
Precisely, because they're seeking to intervene in order to prevent that expression happening in the future. It seems to me, I submit this is a straightforward interference for the reasons that we've just looked at. Another step in the control, the final cut in the control. On this occasion, we will stifle the voice of those that elect the council and the mayor. And
But this, if you're right about this, this has the effects that although it is for the legislature to decide whether or not there should be municipal elections, the fact that there have in the past been municipal elections means that the legislature can't abolish municipal elections, because that is a withdrawal of the right to vote and speak, in a sense, in elections which exist at the moment. The result of which is that it's not actually for the legislature to decide whether there are elections, because there have been elections in the past, any attempt to revoke them is an interference with freedom of expression. Can't be right, can it?
My Lord, with great respect, it can. Because
so the legislature can, in fact, never abolish municipal elections.
Well, with great respect, context is all. Context.
Well, you said that once before, but as I understand it, the context which you rely on is that there have been elections for 300 years. You say in that context, it's an interference with freedom of expression to abolish the elections. That has the consequence that the legislature of Bermuda is incapable of abolishing municipal elections.
Well, when I say context is all, what I mean is there is an historic context here. Mm-hmm. I mentioned simply, perhaps it was more to put it in context rather than to take any legal point on it. But the fact is that the elections take place now. There are free and fair elections at the moment in Hamilton. Of course, the legislature have power and possibly power to abolish elections and replace them with something else at some point. But in a country which is a constitutional democracy and is a rights-based democracy, when they do so, we have to look at whether their legislative freedom is constrained in any way by the Constitution. Where do we look? In this case, I say, we look at Section 9, and we see that there is a right to expression which, under the jurisprudence of the European Convention and elsewhere, is regarded as a fundamental expression right. And we look at the context, which shows that, and we don't wish to go to too many motives, but we notice that this is being done in order to ultimately control a municipal body and put it under, effectively under the thumb of the central government. And this is the last way of doing that, by stifling the voices of those who, the last vestige of independence in thought, independence of expression. And in doing so, we submit that this is a clear violation of Section 9. Yes, of course, the legislature might want to put in and do anything with the electoral system. It may do so in the future, but it will also be constrained by the Constitution. And it should be, and we submit that it is now constrained because the Section 9 is a freestanding right, doesn't need any right to an election, but it is in the context of people who have been voting for many, many years, who are voting now, will be deprived of voting if this reform bill goes through, and who will regard themselves as sincerely truncated in their opportunity to express their views.
Well, just a minute. You say it may do so in future. The reform bill is the means by which the legislature is poised. Yeah. So we're not talking about something in the.
No, I'm saying what I meant was it's my point about context. In the case of this particular reform bill, and its history and its purpose, it is brought forward for the purpose of and the effect, I should say, of impeding the expression of persons in the choice of their government.
But that means, that has the consequence that the legislature is bound to keep the elections for eternity, if you're right.
Lord, as I say, this is a very fact-specific, if you like, situation.
Yes, well, on the specific facts of this case.
The specific facts of these cases, those that I've set out with respect, and they have to do with the bills that have been, what's been going on over the last 10 years. It may, in the future, perhaps the government will say that it will be decided that local government should be abolished. There might be a referendum. People might vote heavily in favor of abolishing local authorities entirely. In that case, it might be a moment when the government would consider abolishing elections entirely. This would be a prima facie interference with some people's freedom of existing expression, let's put it that way.
So Jeffrey, sorry, can I just see if I understand your point? Are you saying that if the government were to abolish the concept of separate municipalities, it would be, or that would be a different story? That would be the supremacy of Parliament and a non-interference with voting rights. And the way in which they've done it in this way, which is to preserve the municipality, preserve the corporation, but interfere with electoral voting rights, is not all right. I mean, are you accepting that if there was a full-scale abolition of the municipalities or the mayor and corporation, that would be a different story?
Milady, absolutely agree. I think that that course of action has a kind of constitutional integrity about it. I think the present situation lacks that integrity. Why? Because it is pretending in some ways. Pretending is not a perfect word, but there is a kind of simulation here. There are mirrors involved. And it is saying this is a corporation, a local corporation, which has been there for many, many years and continues. As I understand it, there was an option to abolish. In a sense,
sorry, there was what?
There was an option to abolish, which was considered
to abolish the corporation. Yeah.
To abolish the corporation. This was not pursued. We have here a situation where it continues. It is a corporation. An argument could be made, so my Lord President asked me a question on this earlier, that being a corporation by implication and by context and by history and so on, an essential feature of that corporation is accountability and expression, through the expression of local electors. That could certainly be argued, and I put it forward without developing it.
Can you remind me, do we have in the evidence the constitution of the corporation or the rules affecting it?
As I understand, we have the 1923 Act, which sets it.
Sorry, say again.
The 1923 Municipalities Act.
And that's where we find their purposes and powers.
Yes.
Right. Okay. Thank you.
Yes, indeed. And,
I'm sorry, I've come. The municipalities are entirely the creation of statute. Are they not?
yes.
They've had different electors from time to time, and they've had different rules, but it is the statute which has created them. And it would seem to me to follow from that it is the statute that can A, abolish them, or B, not abolish them, but change their nature.
The statute, a statute might be able to abolish the corporation. Yes, I think that is.
But your submission, as I understand it, is that given that the corporation remains with its statutory purposes, no doubt, of reflecting the views of its constituents,
yes,
in those circumstances, they can't just abolish the right of the constituents to vote.
Precisely, my lady. That's precisely.
Yes, I see. Thank you.
My Lord, if I may can continue. I now move in paragraph 10 to the approach to the application of section 9. I would refer to the case of Barbie. Which I think is, I would ask you to turn up. It's tab 54C, 54C. Barbie Bishop and the Queen.
Just a moment. I'm afraid I've got to find that.
Tab 54C.
Yeah,
Yes.
And we would submit that paragraph 12, this is a very recent case from the Supreme Court of Bermuda, and we would entirely support the what is set out as the constitutional framework in respect of freedom of expression. In that case, how to go about the exercise of justification and so on. And if you look at paragraph 12, it says the constitutional framework relating to provisions providing for fundamental rights and protections was considered by the court in Brewster. And here it is in summary. A, the framework of the constitutional provisions relating to fundamental rights, including sections 8 and 9, contemplates that it's in the first instance, it is for the applicants to show that there has been a prima facie breach of a fundamental right. And in this regard, the applicant bears the burden of proving this breach. So that's the first step. Has there been a breach of fundamental right? The applicant bears the burden of proving that breach. We say there has been a breach. Once the applicant has discharged the burden of showing a prima facie breach, the respondent must prove that the measures limiting the protected right are reasonably required in the interest of, and these are the limitation clauses, defense, public safety, public order, and so on. So then what happens is that the burden of proof moves. We show that there's been a breach of the provision. Now it's up to my learned friend to say why the measures limiting the protected right are reasonably required in respect of specific limitations. You don't have a general right to say, well, we thought it was a good idea, or, my Lord, that we are sovereign and therefore we can do anything we like if there is a breach of speech. It's only in the defense of, in the interests of defense, public safety, public order, and so on. And we will say, and we say that neither public order or the purposes of protecting rights, reputations, and freedoms of other persons work for him in this case. They're simply not in issue. So I think he has therefore cannot discharge the burden of showing prima facie breach. Even if he does stand under one of those limitations, paragraph C on page 8 of Barbie says that the requirement showing that a measure restricting the protected right is reasonably required was considered by the Privy Council in De Freitas, where the Privy Council held that the respondent must prove, one, that the legislative objective is sufficiently important to justify limiting a fundamental right. So they would, having got themselves into one of those categories, they must then show that it's sufficiently important. The measure was designed to meet the legislative object or rationally connected to it. And thirdly, that the means used to impair the right are no more than is necessary to accomplish the objective. In other words, the court might ask them to say, well, could you have used what's called a less offensive alternative? Could you have simply removed some electors, perhaps these or the others, and kept jigged things round a bit? Why did you have to destroy the whole operation of elections, destroy them entirely, replace them so centrally? Could you have pursued a lesser objective? So
well, that's an interesting question, but what has happened in the present case is that because you never put this forward at first instance, the government or minister hasn't had the opportunity of attempting to discharge the burden of proof, since the assertion didn't arise until the case before us.
Well, what we say, my lord, is that that there is little hope of him hurdling the first limitation clause, because he would have to show that he is acting for the purposes of defense, public safety, public order, public morality, or public health, or for purposes of protecting rights, reputations, and freedoms of other persons. which we say do not apply here. There's no way. This has never been, there's a huge amount of evidence in this case.
Sorry, I couldn't hear you. Somebody
There's
made
a
a
great
noise.
amount of evidence in this case. And one has to recall also that in the court below, the allegation against the government was one of irrationality. So there was much evidence produced on that point, on the reasonableness of the entire exercise. And there is absolutely no evidence of any reason for doing this for the purpose of defense, public safety, public order, public morality, public health, or protecting the rights, reputations, and freedoms of other persons.
Yeah, because of course there wasn't any issue directed to that, because the matter didn't arise. Since you weren't relying below on freedom of expression, it's not entirely surprising that there isn't any evidence relating to whether or not there was an exception to freedom of expression.
The allegation at the time was even broader. It was irrationality. And even in response to that allegation, which is about as wide as you could get, nobody brought in the excuse of public order or the freedoms of others. They would have surely have come up in that context. Voluminous evidence in this case to the fact that nobody's ever suggested, just no evidence of any of these motives anywhere, and I would submit that any of those motives would have to be concocted with due respect if we were to get anywhere near it. We raise a much narrower point than that was raised below. It was considered whether to pursue the rationality charge allegation, and it was decided no, we'll narrow that considerably and take other constitutional points which had not been pressed below, although some of them had arisen. Now, the respondent yesterday, my learned friend yesterday said he would wish to invoke the rights, reputations, and others under subsection 2A2 of section 9. But we think that would avail him nothing. And this is another answer to your point, my lord, because he's now resting not so much on public order, because we think that's clearly excluded by the case which I mentioned. But he now has changed his ground, which he's fully entitled to do. But I think it will avail him nothing, because the exception of the limitation of invoking the rights, reputations of others are classic examples of limitations to prevent, such as defamation, which is not in this case, hate speech, which is not in this case, and infringements of privacy. In other words, these are the limitations that might justify the infringement of freedom of expression, because it has to do with raising all sorts of issues of privacy or reputation or hate. This is not this case. These are far away from this case. And on that point too, my learned friend yesterday said that the court should give a wide margin of appreciation to the government on this matter, that we should give them huge leeway here and say, look, you are sovereign and you can decide, and it's a matter of policy for you. And we give you a very wide margin of appreciation. But I'm afraid I must contend that speech rights are very strictly applied in all the case law and jurisprudence of the European Convention and elsewhere. And in any event, the notion of margin of appreciation in this context applies only to the level of the European Court of Human Rights. This is my paragraph 12, in respect of different countries, which may have different cultural values in respect of those rights, where that may be relevant. My lords, you have the Handyside case. I've extracted the relevant paragraphs, which I will now read. The court points out that the machinery of protection established by the Convention is subsidiary to the national systems safeguarding human rights, the Convention leaves each contracting state in the first place the task of securing the rights and liberties it shrines. The institutions created by it make their own contribution to this task, but they become involved only through contentious proceedings, and once all domestic remedies have been exhausted. These observations apply to Article 10. In particular, it is not possible to find in the domestic law of the various contracting states a uniform European conception of morals. So that's where the margin of appreciation comes in. At the European level, you might find that in a country like Italy, they would have a different conception of morals from a country that was predominantly of a different religious background. The view taken by the respective laws of the requirement of morals varies from time to time, from place to place, especially in our area, which is characterized by a rapid and far-reaching evolution of opinions on the subject. By reason of their direct and continuous contact with the vital forces of their country, state authorities are in principle in a better position than the international judge to give an opinion on the exact content of these requirements, as well as on the necessity of restriction and penalty intended to meet them. So the answer to this is yes, on the international level, on the regional level of the European Court, you might give a margin of appreciation in some speech matters to the particular country because of the different cultures, but not here. A strict standard applies. And then it continues. Nevertheless, Article 10 does not give the contracting states an unlimited power of appreciation. The court, which with the Commission is responsible for ensuring the observance of the state's engagement, is empowered to give the final ruling whether a restriction or penalty is reconcilable with freedom of expression. The domestic margin of appreciation goes hand in hand with the European supervision. Such supervision concerns both the aim of the mother tenants and its necessity. It covers not only the basic legislation, but also the decision applying it, even one given by an independent court. All I seek to derive from that rather overlong statement is that my learned friend devoted some time and some force yesterday to this question of margin appreciation.
Wait a moment. You say in paragraph 12, line 2, speech rights are strictly applied, and in any event, the margin of appreciation in this context applies only at the level of the ECHR. But if you look at the last paragraph that you have referred to us, it refers 4 lines up from the bottom. The domestic margin of appreciation thus goes hand in hand with the European supervision. So far from saying that the margin of appreciation only applies at the European court level, it refers to a domestic margin of appreciation as well as a European court margin of appreciation.
Well, Lord, with the greatest respect, I didn't read that as saying that. I think the court was very clear in the second paragraph on page 5 when they say that in Europe as a whole, there may be very different respective requirements in respect of morals. And what it's saying here is that the domestic margin of appreciation, the way they determine the margin of appreciation will, in any event, goes hand in hand with our supervision. We will supervise it, but we will give them, each country, a certain degree of leeway. But I don't think that, with respect to that statement, does not indicate that in respect of speech, this has never been the case. Speech is one of the most tightly.
What did they mean by the domestic margin of appreciation, which you say doesn't exist?
Well, as I read it, they're saying that any leeway that a domestic court might give, e.g., a country with fervent religious convictions, might not give much leeway to wearing headscarves, for example, and apply it narrowly, or it might not. It's up to them to decide how they do it. It's their independence in that respect. But it marches hand in hand with us because we supervise it. And there may be cases where they've gone too far forbidding religious symbols, for example, in Italy. It's up to Italy to decide whether they want to allow them or forbid them. But we have a supervisory, we always have a sort of simply asserting their authority. But the whole tenor of the passage suggests that we at our level realize that things are somewhat different, that there are different cultural values below in the different countries. You must decide your own, and then we'll supervise it. That, I think, in a nutshell, is what they were saying. So we see there's nothing, certainly in section 9, that suggests that you should give a great margin of appreciation in this case, where it is the domestic court of Bermuda applying the domestic constitution of Bermuda to test the compatibility of Bermudan legislation with the Bermudan constitution. And we, on the contrary, we would say that any attempt to strict rights in that context, quite the contrary, warrants what we would say is anxious scrutiny. Very anxious scrutiny. We think speech is a fundamental right, and that there is in our submissions a statement, again by Lord Steyn in the Sims case, which you looked at earlier, a ringing endorsement of of freedom of expression, why it is probably the most important of all rights, and why he considers it so. Again, those are not my almost my full submissions. But going back again to one point, I think I might have underemphasized somewhat, and that is only this, that freedom of expression, in relation to the point which my Lord took yesterday against me, that you need both an expression right and a right to vote in this particular case. I refer you again to just paragraph 8 of my submission. It's a bit cryptic, but there are two different. This is not freedom of expression is a completely freestanding right on its own. It covers the situation of elections. It fits perfectly in this case. I won't use the word context again, but in the way that this has all been developed and has reached this point. And so therefore, we say that it applies fully in this situation. Well, I think that really completes my...
Can I just ask a question that's of a housekeeping nature, Sir Geoffrey? Yesterday, Mr. Duncan was saying that in relation to this point, by reason of it not having been raised below, he'd been deprived of the opportunity to file evidence, and Mr. Myers interjected to say that the best evidence was already in the record in the form of a survey in relation to the views of Bermudian people. Could we have the reference to that evidence? I see Mr. Myers is going to find it now.
Can I also either Mr. Myers, do you have it now, or you can produce it a little later?
Can I do that just a little bit later? I will give you the exact reference.
That's fine. Thank you very much. I've got two outstanding questions. The European Convention has an attached protocol which gives rights in relation to elections. It's either Article 3 of the first protocol or Article 1 of the third protocol. I can't remember which. It doesn't matter.
Article 3 of the first.
It is Article 3 of the first protocol, it might be thought that that is illustrative of the fact that the convention and others that follow it is not intended in Article 9 or the equivalent to confer any right to freedom of expression at an election, because whether or not you're entitled to an election in the first place is not dealt with in the convention other than in Article 3 of the first protocol, which doesn't exist in Bermuda. You got any observations on that line of approach?
My European Commission. Yes, that's absolutely right. I mean, the protocol came later. I have the convention somewhere here. It was never said that there's never been any statement whatsoever. We did search this in any of the jurisprudence of the European Court that the Article 10 expression right excludes anything to do with elections. On the contrary, and I refer to some of the cases that I've mentioned, from the start, they have always said that they come together. It's a form of expression. It's a form of what's known political expression. Voting is political expression. And if necessary, I could provide cases on that. But it was never said that Article 10 didn't cover elections. The protocol, the Article A3P1 came in response more, as I recall, but this is personal knowledge to, I think, I shouldn't actually say what it came in response, but it could have been to the fall of the Soviet Union and requiring legislators to be proper legislators after 1990. But I may be wrong on that, and I'd prefer to just research that before coming up with that statement. But I think that that's why it was introduced.
Right. The other thing that I would like, lastly, assistance on, well, penultimately actually, is I wonder if you could go to the supplemental skeleton submissions for the respondents of the 17th of November.
#10th of November.
Well, I may be able to deal with it in a different way. If you go to your submissions, your original submissions on the appeal, page 54, paragraph 145.
Yes.
Have you got that?
I'll come to that in two. Page 55, right there. Paragraph
145. What you say there is this: to be clear, it is not here asserted that under the terms of the Constitution there is a right to local government or a right to the democratic election of a local government corporation sole. Our submission is that the contravention of the Constitution lies in the removal of an extant democratic mechanism on the grounds that its decisions and opinions have offended or are unlikely to offend an opposing party now in government. Now, the reference to on the ground that its decisions and opinions have offended or are likely to offend the opposing party is no longer before us, because you've abandoned any question of motive. And in those circumstances, if, as you were saying, to be clear, it was not asserted that there was a right to the democratic election of a local government corporation sole, are you not, in effect, in your latest submissions, departing from that proposition?
I think I probably have made the assertion more nuanced.
Say that again. You've made the assertion more nuanced.
More nuanced.
I think that's a yes expressed rather delicately.
But I think in certain circumstances, it might be difficult to do that. Let me just be clear, my lord, that I've answered your question. What are you asking me to say that I might endorse or resile from?
Well, what you were saying was, to be clear, it wasn't your contention that there was a right to the democratic election of a local government corporation sole.
Oh, yes.
But it appeared to me that the submissions to us amount to the proposition that there is a right to have a local government corporation sole.
No, I don't think, well...
To be fair to you...
In this particular case, all I am asserting is that there is... I'm not addressing the question, really, of the right of the Assembly to abolish or do anything else that they want to do with the corporation sole. That isn't really in my frame. What is in my frame is the situation as it has recently happened. Namely that in the context, I'm sorry if I'm using that word excessively, but I will think of another in a moment if I can. In terms of the recent history, it is clear. Sorry, let me rephrase that. In terms of recent events, it seems clear that what is being proposed in the reform bill, given that there is an extant corporation and extant voting system, amounts to an interference with the expression of those who presently vote. The reason I said I have a nuanced view of it, I think there is an argument, which I've submitted without development, that it is the essence of this corporation that it is held that its council and mayors be elected and held accountable by virtue of the foundational document under which they are founded, which is the 1923 Act. So that is a further buttress to my previous statement. That is what I'm looking to, the present situation. I make no comment on what might be done in the future.
Well, you do, because you say what can't be done in the future is what's going to be done in the reform bill if it becomes an act.
Well, I suppose we're looking at, only in this context, but it's unusual in a case like this to look at a bill. And in some ways you're assuming that the bill is under our scrutiny at the moment, which makes. But
that's exactly why we're here. That's exactly what we're here for. Yes. You say that the bill, if passed, will infringe rights. You can't say, oh, well, that's all for the future. The whole reason. Can you?
My Lord, I'm taking, when I say the future, I'm excluding this bill and its immediate aftermath, whatever might happen to it. I'm talking about another case. On this occasion, I say it would be an infringement of expression to abolish elections.
Okay.
In the future, I don't address that issue.
Okay, thank you. Right. Well, thank you very much. Now, I'm afraid there is one further complication in that a little while ago, there was sent to us a supplemental note of the appellant, which largely goes to which decisions of this court and other places were ratio. And it appears to me that what is in this note goes back on what you said when you were opening the case to us originally. I don't know who can deal with this, whether it's you or Mr. Myers, but since I take that view in relation to some of it, I think I ought to give one or other of you the opportunity to deal with my queries in relation to the latest note.
I will try, my lord.
Okay, have you got the note in front of you?
I do indeed, my lord.
Well, I'm not going to go through all of it, but you say in item 3, what was said in Great Bay was not in any event ratio in light of the principle referred to in the extract from Hallsbury's, referring to Al Melidawi.
Yes.
And that doesn't deal with the fact that Al Melidawi itself went to the House of Lords, or who didn't find it necessary to deal with what the Court of Appeal had decided in Al Melidawi, which could be said itself to mean that what it was said in Melidawi was, according to the doctrine in Melidawi, not ratio.
My lord, I would respond this way. Firstly, we can't, I mean, Al-Medawi isn't binding in Bermuda anyway. So in any event, the question of whether it's ratio or not ratio doesn't really arise in the context.
Yes.
So we're we're putting it forward as being highly persuasive. And secondly, if your lordship would look at the case, I hope you have it, of Helena Partnerships, which I think was sent to you.
Yes.
If you look at paragraph 55, I'll just refer to that one paragraph. Paragraph 55 of that case tells you what Al-Medawi, I think is how you pronounce it, means. And it reads like this. If the decision of the Court of Appeal had not been subject to an appeal, that statement might have been part of the ratio decidendi, talking about another case. However, since it was appealed and since the decision of the House went on a different basis, what the Court of Appeal said cannot be regarded as part of the ratio of that case. Thus, the Court of Appeal's decision on that point was the last word. This is, he's talking about Al-Medawi. He says the House of Lords in Al-Medawi did not accept Lord Justice Taylor's invitation to consider the stare decisis aspect. And the court goes on, thus, the Court of Appeal's decision on the point, as distinct from the substantive issue in the case, was the last word in those proceedings on that subject. Accordingly, on that point, as it seems to me, says the United Kingdom Court of Appeal, we are bound by what the Court of Appeal said in Al-Medawi.
Well, that's not right, because on the principle of Al-Medawi itself.
I agree.
Yes, right. And we're
I
not
agree entirely.
that.
I'm just saying this is how the Court of Appeal in the United Kingdom has treated the Al-Medawi case, which only adds to our submission that it is should be given high regard. That's all.
Well, high regard is one thing,
Not
ratio is another. Okay.
Well, it
there
can't
are
be
two-
binding anyway,
There
madam.
are two decisions of the Court of Appeal of England, neither of which is binding on us,
Correct.
and the second of which is inconsistent with the basis of the first.
That may be an appropriate summary.
Yes. Apart from that, it's fine. Okay. Next item on the program, you say fourth, Inchcup did not make any binding choice between conflicting previous binding ratio decisions, and Inchcup was in any event obiter and was not therefore binding. The commentary on section 1 not being necessary for the result, given the court had found that the fundamental basis for its application, namely a deprivation of property, had not been satisfied.
That's
Now,
not.
when Sir Geoffrey was addressing us, my note was that he said perhaps it is ratio. Now, that's not a final acceptance that it is ratio, but yeah. But the problem is this. The court in Inchcup, if I recall, said that section 1 didn't give an independent right.
Yes, my lord.
And in any event, there hadn't been a deprivation of property within the meaning of that section.
Yes, my lord.
Now, I have some difficulty in thinking that that wasn't a ratio decision.
Yes, my lord.
That section 1 did not have independent application.
Yes, my lord. Actually, it's quite interesting because if you compare Inchcup to a Great Bay in the Privy Council,
Yes.
in the Privy Council, Lord Hoffman said, I don't need to decide the question of the independent enforceability of section 1 because
so
I'm quite, yes, and he said the reason I don't need to do that is because I'm quite sure that there's no deprivation of property. And that is precisely what happened in Inchcup.
Yeah, but Inchcup didn't say I don't need to decide whether section 1 it has independent force.
I agree, my lord.
And it seems to me, this is what I want to give you the opportunity of dealing with, is that if a court says the section has independent force, but on the facts, the complainant doesn't come within it, its decision that the section 1 has independent force is part of the ratio.
But although I'm not sure that's exactly what took place in the Inchcup case, my lord, you might recall that one of the things that the Chief Justice said in the first instance judgment was that the question of the enforceability of section 1 didn't arise before him because, as he held, there was no deprivation of property. That approach or that result is reflected in the Court of Appeal. The Court of Appeal refers to that, I think, in one of the first passages, Act 12. It's paragraph 8 of the judgment.
What, the Court of Appeal?
Yes, my lord.
Well, I'm not interested in the Court of Appeal.
Okay.
I'm interested in the decision in Inchcup.
This is the decision in Inchcup, my lord. At tab
No,
12.
the decision of the, I'm so sorry, the decision of the Supreme Court.
This is what the Court of Appeal describes the Supreme Court decision as deciding. That's what I'm looking at.
Where is that?
That is at paragraph 8 of tab 12.
Well, paragraph, I'm sorry. No, I mean the paragraph 8 of tab 12 says the Chief Justice held
Yes, my lord.
that 5, it was unnecessary to decide whether section 1 of the legislation gave rise to a free standing right. Go further down. In this appeal, the appellants challenge all these holdings. And then it goes on to say, does section 1 of the Constitution give the appellant a freestanding and enforceable right? And
Yes, my
in
lord.
paragraphs 9, 10, 11, 12, 13, they go through all the cases and say, in effect, that section 1 does give a freestanding right.
Yes, my lord. But is the question not looking at the case, at the propositions of law in relation to the facts of the case, was the holding that Section 1 was enforceable necessary for the result?
Well, I'm not convinced that that can be the test.
Oh, I see, my lord.
Take the following example. Assume that in order to succeed, it is necessary for the plaintiff to succeed on 4 points.
Yes.
He fails on all 4 of them.
Okay.
Is it to be said that none of them are part of the ratio? Because the decision on point 1 wasn't necessary for the result, because the decisions on points 2, 3, and 4 would be sufficient to ensure that the plaintiff lost.
It may well be the case that it could be said that the decisions on point 2, 3, and 4 decided the case, and that the decision on point 1 wasn't necessary because 2, 3, and 4 made 1, as it were, redundant. But it's
it could be also said that point 1 decided the case, because unless you succeeded on point 1,
I see what
you wouldn't recover, and 2, 3, and 4 were unnecessary.
But I think it's a slightly different situation in Inchclub on Section 1, though, because a fundamental condition for Section 1 to have any relevance is that there be a deprivation of property. If that fundamental condition is not met, then Section 1 can have no relevance.
Well, wait a moment. When you let us assume you have a question as to whether or not a contract means X.
Yes.
Pages and pages are devoted, and the judge says, I'm clearly of the opinion that the contract means X.
Yes.
But on the facts, I find that the plaintiff doesn't recover.
Mm-hmm.
Is his decision on X wholly obiter?
No, my lord. But that's a slightly different example, though, isn't it?
No, it isn't. It isn't. In the same example, his decision on X was not necessary for the result because the plaintiff would have failed in any event.
I think what I'm saying is that as a matter of law, in order for Section 1 to be relevant, it would be necessary for the conditions of Section 1 to be met. If I hold that the conditions of Section 1 cannot be met, then what I say about Section 1 is really neither here nor there, because those conditions cannot be met, and therefore, whether or not Section 1 is enforceable doesn't really arise. And that's why the Chief Justice held as he did.
Well, wait a minute. The Chief Justice, yeah, okay. Well, a similar position arises in relation to Ferguson.
Yes, my lord.
You say 7th. That what was said in Ferguson was obiter, though I think Sir Geoffrey accepted in argument that it was ratio, and was therefore not binding, the case being decided on entirely different grounds in any event, and further that Ferguson followed Inchclub without reasoning or explanation of any kind. Well, that's a different point. But in relation to Ferguson, if we go to tab 33, which is where it is to be found, if I can try and find it. Give me a moment. Yeah. Ferguson is at tab 33. And in relation to that, the judge had to decide, well, this court had to decide a number of matters, and it dealt with section 1 at paragraph 76 on page 702 at the very end.
Yes.
Mr. Pettigill, on behalf of Ferguson, submits the DPA is void for additional reasons, he submits that his constitutional rights have also been breached under section 1A, 9 and 10. Section 1A is not an independently enforceable right. Now, isn't that an independent decision by way of ratio?
My lord, can I direct your attention to the next paragraph, which is paragraph 77?
Mm.
The revocation provisions of the DPA were passed for a mainly religious purpose to meet the wishes of the PMB. They are therefore invalid and must be struck down. We dismiss the appeal and uphold the decision of the Chief Justice, but on that ground.
Yeah, I see. Right.
We uphold the decision of the Chief Justice that there's a breach of section 8, but not its decision on 12. So we dismiss the appeal and uphold the decision of the Chief Justice on that ground. That is the ground on which the appeal was upheld.
Right.
That's the ratio ground, as it were.
Yes. Well, yes, I follow. So the Chief Justice was wrong in that, was he, in that passage of his judgment, where he says that if the judge makes a decision on a distinct part of the case, that can count as the ratio as well.
I think that is wrong, my lord, with respect.
Ah, okay. Thank you.
Thank you, my lord.
Right. Where have we got to? Mr. Duncan, do you want to
Yes,
deal
my
with
lord.
your latest material?
Yes, my lord. Thank you. It is a document that hopefully you have uploaded on the cloud. I would like.
Yes, I printed mine out, but I'm sure my colleagues have them on the cloud.
Yes, thank you. I'd like to. Sorry, my lord.
I have mine printed too, Mr. Duncan.
Yeah, I'd like to start at paragraph 3 of that document. And the purpose of this is to respond to and try and assist the court put in writing the submissions that were filed yesterday by Sir Geoffrey and Mr. Myers. Paragraph 3, the respondent reiterates the rule of law submissions dated the 10th of November, in which authority is provided in relation to the relevant provisions of statutory interpretation, particularly interpreting a statutory provision in the context of the statute as a whole. And I refer to paragraph 25 of those submissions, which I'll just read quickly because it is quite important. So paragraph 25 of the rule of law submissions. Now, paragraph 25 of the rule of law submissions is the third proposition in relation to fundamental flaws in the rule of law argument. Now, I'll just read paragraph 25. Thirdly, it is important to note that the minister's power in section 7AA is to give directions. The appellant is a body corporate with limited powers, and I emphasize the word powers, conferred under the Municipalities Act. Section 7AA does not confer the minister a power to give the appellant more powers than it has under the Municipalities Act. As such, the minister clearly cannot direct the appellant to do an act or thing that the appellant is not already empowered to do under the Act. With that, if I can turn back to the submissions filed today and start at paragraph 4 of those appears to be that the minister is empowered to direct the jurisdiction of the corporation beyond the scope of the Municipalities Act by any direction being deemed for municipal purposes and a function of the corporation. Can I ask the members of the panel to, for convenience sake, turn to the rule of law skeleton argument, paragraph 18, where conveniently section 7AA is set out. We will go to the legislation shortly, but in the rule of law skeleton, paragraph 18, section 7AA is set out. And it reads, the minister may give written directions to the corporation, whether of a general or of a specific character, and if he considered it to be in the best interest of Bermuda, for him to do so, and the corporation shall carry out any such directions. Any act or thing required to be done by a corporation in pursuance of directions given under subsection 1 shall be deemed to be for municipal, and I ask the court to emphasize, purposes, and B is a function of the corporation. So the emphasis on the words in subsection 1, direction, and then in 1A, deemed to be for municipal purposes, and in B, function. So we've got directions in relation to purposes and functions. Turning back to the skeleton argument that I filed today, paragraph 4, the appellant's case appears to be that the minister is empowered to direct the jurisdiction of the corporation beyond the scope of the Municipalities Act by any direction being deemed to be for municipal purposes and a function of the corporation. The appellant has missed a clear distinction between municipal purposes and the corporation's functions on the one hand, and the corporation's powers on the other hand. Paragraph 5. Section 7AA only confers on the minister a power to give directions that are deemed to be for municipal purposes and a function of the corporation. However, the focus on the deeming provision is misguided. The appellant is a body corporate and only possesses those specific powers expressly provided for under the Municipalities Act. There is no general power conferred on the corporation to give effect to municipal purposes or functions. As such, it matters not that what the minister directs is deemed a municipal purpose. The fact is, section 7AA does not confer on the minister a power to give the corporation more or wider powers than it has under the Municipalities Act. Section 7AA can therefore only properly be understood as giving the minister a power to give directions in accordance with the corporation's specific powers set out in the Municipalities Act. Put another way, the minister would not be able to direct the appellant to do an act or thing that the appellant is not already empowered to do under the Municipalities Act. The references to the corporation's functions and purposes in the Municipalities Act are limited, and the provisions containing the corporation's powers are distinct from those references. They are distinct features. Some of the corporation's powers include, and can I ask the tribunal, members of the panel, to look at the binder containing the Municipalities Act. If I can ask you to turn to section 22.
Which act are we looking at?
Can I ask, sorry, my lord, tab 8. It's tab 8 of that binder. It's the Principal Act. Tab 8.
Section 22.
My lord, yes. Yes, there's a reference in.
Sorry, Mr. Duncan, my tab 8 may not be the same as your tab 8. What are we looking at?
We're looking at the Principal Act, my lady. It's the 1923 Act.
Okay, I have that.
Yes.
Somewhere else.
So at section 20, it says powers of corporation with respect to real and personal property. I'll come back to that. But at section 22, which is referred to in paragraph 7 of the skeleton, you see powers of the corporation to acquire land.
Sorry, give me the section again. I apologize.
22.
Thank you.
Says the corporations of Hamilton and St. George's shall have the like powers for taking up any land with their respective municipalities, which may be required for the purposes of widening any of the public streets, etc. And then it says, in construing the provisions of acquisition of land made applicable by subsection 1 to expropriation proceedings under this act, the following substitution shall apply. That's not really that relevant. Lady, if I can ask you and my lords to look at section 7b, which is section 23(1) of the Act. So paragraph 7 of the skeleton, and that is section 23(1) of the same Act. The power to levy rates on valuation units within the limits of Hamilton for one or more purposes. So what we've got so far is we've got section 20 and 23 referring to the section 20 and 22 referring to the power with respect to land, section 23 referring to the power to levy rates, and then we've got section 31, the power of the corporation to levy wharfage, payment of wharfage, lien on goods. These are specific powers. And then you've got section 37, which is paragraph 7D of the skeleton, and that is the power to borrow money or to provide a guarantee. In paragraph 8 of the skeleton argument, we say such powers may refer to purposes. For example,
I'm sorry, Mr. Duncan, can I just take you back to paragraph 5 and the passage that you referred to there, that saying section 7AA can therefore only be properly understood as giving the minister a power to give directions in accordance with the corporation's specific powers. Am I not right in recalling that the minister, the late Walton Brown, who was then Minister of Home Affairs, speaking in the House of Assembly, specifically referred to the Mexico infrastructure case, pointing out that the purpose of the Reform Act was to get round the constraints of having to act within municipal powers.
No, my lord, within municipal purposes, not powers. And I'll take you to the case. That's the confusion that has arisen.
I may have misspoken. Did he say municipal purposes? Did he not say? I meant to say municipal purposes.
Yeah, that's the confusion that has arisen in this case. And with the greatest of respect, the appellants have not gone through the legislation and identified it. There is a hierarchy. There are powers, and below that, there are functions and purposes. This legislation, that's why I went to 7AA, gives the minister, and we use the word power, not in terms of the powers in the Act, gives him the authority, I'll use another word, gives him the authority to direct the corporation with respect to purposes and functions that must be within the powers. The section does not give the minister the authority to change a power.
But the minister is empowered to deem a specific purpose to be a municipal purpose.
But that's only if it's a power. It has to be a power. He cannot change a power. And I'll come to explain that. So paragraph 4, the appellant's case appears to be that the minister is empowered to direct the jurisdiction of sorry, I've done that before.
You've done
8.
that.
Yeah, 8. I was on 8. So paragraph 8, such powers may refer to purposes, for example, in section 23(1). So let's have a look at section 23(1).
How to levy rates.
Yes. So the Corporation of Hamilton and St George's may levy and collect annual rates on valuation units within the limits of Hamilton and St George's, respectively, for all or any of the following purposes. So what the minister can direct is the change of a purpose, but he can't change the power.
Well, so does that mean the minister can say, you can levy rates for the purposes of building an aerodrome?
Yeah.
Not if that building wasn't within the power that he was already in the act. There has to be a power within the act. So, my lord,
but wait a minute, the power in the act is to levy this power for a number of purposes. You said that the minister can't change the powers, but can deal with the purposes.
Yes.
Well, if he says, in addition to the purposes in 23, I'd like you to build an aerodrome, please raise some rates for that. Surely that comes within 7A1A.
So what you're saying is, first he would have to have the give a direction. Did you say, my lord, make sure I have it correctly, levy rates on an airport that he builds, or an airport that's already in existence? Or
No, for
Building an aerodrome within the city.
well, we'd have to see what the power of building is first.
Well, looking at section 23(1), he's just adding as H the additional purpose of building an aerodrome within the city.
But, my lord, this is how we would say that the court should construe the interaction between powers on the one hand and functions and purposes on the other hand. First of all, what has to be decided is when the minister gives a direction, first of all, is it in the interests of Bermuda? That's the first point. Secondly, and that's in the amendment. Secondly, has there been consultation on that particular point? Thirdly, how wide is the power with respect to the particular purpose that he is seeking to direct? And if that purpose is within the confines of a statutory power, then he can deem that additional purpose. But what he can't do is extend that power by deeming a purpose that is outside the width of that power. And the reality is that when we look at the way in which the minister deems a purpose or a function, he must follow all the rules of statutory interpretation and constitutionality that we have gone through already. It's not just the minister can do what he wants. He is constrained by the fact that he cannot deem powers. He can deem purposes. And to take an example, let's let me continue, because I want to get to the Mexico infrastructure case and explain it through that case. Our submission in paragraph 9, before I go there, I don't think I finished paragraph 8 before my lord asked me a question. So paragraph 8, such powers that are referred to in section 23(1) to levy rates is to be exercised for all or any one of the purposes set out therein. Subsection 1F generally describes one such category of purposes as such municipal purposes being purposes of an extraordinary nature as the minister may in any particular case approve. But he cannot create and widen that power. He doesn't have that authority because the legislation doesn't give him that authority. Paragraph 9, the minister's power to give directions, or authority, it's a better word, to give directions, as set out in section 7A, does not permit the minister to expand the corporation's powers under the Act. As such, any direction given by the minister must be one that the corporation is able to carry out, arising or using the very specific powers in the Municipalities Act. The emphasis on purposes and functions of the corporation is misguided, because those purposes and functions are meaningless unless the corporation has the power to give them effect. Such power can only be conferred by the Act, not the minister. The appellant has clearly misapprehended the scope of section 7AA. The appellant contends that 7AA enables the minister to extend the powers of a body with inevitably limited powers. However, the appellant has in fact made no effort to explain this argument with reference to the provisions of the Act. Such an exercise is necessary to explain the ambit of individual provisions, given that the provision is not enacted in a vacuum. And this is where Pearson and the quotes we took you to in Pearson make far more sense. And that's set out in the rule of law submission. Had the appellant taken the Court of Appeal through the necessary statutory analysis, it would have become apparent that 7AA does not confer authority to amend the foundation of power conferred by the executive without any parliamentary oversight, as submitted by Sir Geoffrey in paragraph 2 of the supplementary note. There is no authority to extend powers. For example, the corporation's powers to enter into an agreement to sell land or to grant of a lease exceeding a term of 21 years are subject to the requirement for approval by cabinet and the legislature. And I can take you to that in section 21A. So if I could take you to section 21A of the Municipalities Act, it reads as follows on page 25. Subject to subsections 1A to 1C, the corporations of Hamilton and St. George's respectively are hereby empowered to purchase, take hold, mortgage, pledge, deal with, dispose of, at their own will and pleasure, all manner of goods, chattels, and other personal property, and to purchase, take hold, receive, enjoy, and give grant, lease, etc., land in Bermuda, in fee simple or for a term of life or years or in any other manner. 1A, any agreement for the sale of land which is the property of the corporation, or a lease, conveyance, or other disposition of any interest in land which is the property of the corporation, being a lease disposition or conveyance expressed to be for a term exceeding 21 years, or for the terms renewable exceeding in the aggregate 21 years, or any related agreement, must be submitted in draft to the minister for approval by the cabinet and be approved by the legislature. So all this talk about section 13 and deprivation of property was, if I may say respectfully, out of context. For example, paragraph 11 of the submission. The Act clearly does not envisage that the minister can give a direction under 7AA that would have the effect of circumventing this restriction. Paragraph 12. Similarly, the minister cannot direct the corporation to borrow or provide a guarantee in terms that would circumvent the restrictions set out in section 37. Section 37(1)(a) prohibits the corporation from borrowing or providing guarantees in excess of 30 million without authorization from the legislature. Paragraph 13. Thus, in Mexico infrastructure, the power to issue a guarantee was considered an existing power of the corporation. The issue was whether or not the exercise of that existing power was for a municipal purpose under section 23F. And if we can have a look at that authority at tab 63,
Moment. Yes.
tab 63, can I ask the court to look at paragraph 5 indicates the corporation did not seek to raise rates to enable it to execute the guarantee, but it sought ministerial approval to execute the guarantee under section 23(1)(f) of the 1923 Act, which is set out below, enables the corporation to levy rates for municipal purposes of an extraordinary nature, but only with ministerial approval. The minister declined to give approval because of the concerns about the corporation's powers, and so informed the corporation on the 10th of July, 2013. If I can now ask you to look at paragraph 14.
1.4.
1.4, please, yes. Regarding guarantees, there is no express power to issue guarantees, so the power is said to be implied from other provisions, in particular, the power to levy rates conferred by section 23(1) of the Act. And then paragraph 26. Paragraph 26. The amendment to section 37 made by the 2013 Act now makes clear that the corporation has an implied power to issue guarantees within the limits imposed by section 37(1) of the 1923 Act as amended. However, as explained, those guarantees cannot be an activity in themselves and must therefore be issued for an authorized purpose found elsewhere in the 1923 Act. So the whole point of that litigation was there was no power there was no purpose, but there was an implied power. And so what we say, my lord, in paragraph 13 is that since the enactment of section 7AA, the minister could direct the corporation to provide the guarantee, which would be deemed for municipal purposes, as it would be in the exercise of an existing power conferred on the corporation under the Municipalities Act, section 37(1). Conversely, the minister could not direct the corporation to provide a guarantee in excess of 30 million without approval from the legislature, as it is not a power conferred on the corporation under the Act. In short, paragraph 14, the powers of the corporation are limited to those expressly provided for in the Act. Applying.
Sorry, just a moment. You say the minister in 13 could direct the corporation to provide the guarantee as it would be an exercise of an existing power conferred under the corporation under section 37(1).
Yes.
Does that refer specifically to guarantee?
Let's have a look. It does. I think I have it marked. Yes, 37(1). The Corporation of Hamilton. So under the heading, powers of corporation with respect to borrowing.
Yes.
Limit on powers of corporations to borrow money. 37(1). The Corporation of Hamilton St. George's respectively.
Yeah, you're quite right. Sorry.
Right. So continuing paragraph 14, applying the principles of interpretation set out in the rule of law submissions, the minister may give a direction only in relation to those existing.
Wait a minute. I'm sorry. So could the minister give a direction that the corporation should guarantee a loan for the purchase of an aerodrome?
We have to look at the purposes, but
well, 37 gives the corporation power to borrow or guarantee for specific purposes.
yes,
That means any specific purpose.
more potentially yes. if the purposes aren't limited, and they don't seem to be.
No, they don't seem to be. It would appear to, if you say that the minister can specify the purpose, it would appear to be the case that he could tell the corporation that they should guarantee a loan for the construction of an airport, because the corporation has power to guarantee, and he is entitled to specify a purpose.
Yes, but it would have to still go through the statutory interpretation principles that are in the rule of law skeleton argument that we went through. But the important point here, my lord, is that there has been a cart and horses approach to the word purpose, power, and function. There's been no distinction between the two. And the suggestion is that the minister's powers are unlimited because he can do anything. He cannot. The powers within the act are limited. His authority, I'm not going to use the word power, his authority under section 7A is with respect to municipal purposes and functions, not powers. And continuing in paragraph 14, further, the minister giving a direction that has the effect of extending a purpose or function of the corporation is of itself meaningless if there is no existing power to give effect to that direction.
Yeah.
Further, if the minister gives a direction that is outside the scope of the corporation's powers, it can be challenged during the consultation process provided for in 7AA and ultimately by way of judicial review. Lord, and I just want to remind the court again of briefly, the rule of law skeleton argument of the principles in paragraphs 18 through to 30. So we say that the approach that would be taken with each direction is that the minister would give a direction to the corporation. That direction would have to be in the interests of Bermuda. Next, there would have to be a decision made by the corporation. No doubt the minister would make the decision as well, whether direction was within the context of an existing power and during the course of the consultation and decision-making exercise, the question would be, is the deemed purpose or function one that is within the existing powers of the corporation, because the minister has no authority to extend the corporation's powers. So we submit that, to use one of my Lord President's words, if I can use it and not be intemperate, my learned friend's hyperbolic assertions with respect to the extent of the minister's powers are wrong. They are simply wrong. And what should have happened in this case, and I say this with no disrespect, but what should have happened is that the appellants should have gone through the respective pieces of legislation and highlighted the distinction between powers, functions, and purposes, and put section 7AA in proper context. And they failed to do that. My lord, the next point that we make is at paragraph 16.
Well, just before you get to that, I'm now slightly lost as to what the function of 7AA1A is. You say the minister can't, by giving some order, extend the powers of the corporation, but he can extend the purposes for which the powers can be used.
Yes.
And they are deemed to be municipal purposes. I'm trying to find in the Municipalities Act what reference there is to municipal purposes. And the only one I have so far been able to find is 23(1)(f). When we were looking at the other section a moment ago, it didn't refer to municipal purposes, but part of guarantee or borrow. To 37, there was a part of guarantee or borrow for specific purposes. Maybe there's another reference to municipal purposes. But it would seem that the provision that what the minister orders is deemed to be for municipal purposes was intended to, well, certainly to come within 23(1)(f), which allows the corporations to levy rates for the purposes of doing various things, and such municipal purposes being purposes of an extraordinary nature as the minister may in any particular case approve. But I go back to where I was before. But would appear to mean that the minister could order that the corporation should levy a rate or use rates already levied, presumably, for the purpose of building an aerodrome, such municipal, such being the purpose which the minister had approved and which is deemed to be municipal.
Well, my lord, I think we go back to the canons of interpretation that I submitted before that would constrain the exercise of that deeming by the minister.
Well, yes. I mean, you say that if it wasn't in fact a municipal purpose, then the exercise of the power could be challenged of the minister.
Yep.
Right. But you say, I quite follow, you say that there's a distinction between purpose, power, function, and purpose. But if you've got power to change the purpose, that would appear to allow you to do an awful lot, since presumably and when it says that the corporation can levy rates for the following purposes, that must also mean that it's, having raised the rates, it's entitled to use the money that it's raised for the purpose of doing the things that are set out in A to G.
Which would be within the constraints of the power that they already have, yes.
Well, yes, I mean, but the power of the corporation to do anything, to spend any money, presumably arises from 23(1).
Yes.
Yeah.
General power of corporation to levy rates, yes.
Okay. So, although you're right, there's a distinction between power and purpose. Since the corporation can raise rates for municipal purposes, that effectively means, subject to the point that you say it's open to challenge, that the minister can get them to raise money for whatever purpose he chooses, which is deemed to be municipal.
Right, but that is technically correct. But what I would say is this, that that money would probably have to be spent with respect to a further direction on something that was empowered within the Act.
I don't understand that. If
Well,
you've got, how to explain it? If you've got power to raise money for a purpose, you must have power to carry out the purpose for which you raised the money. Otherwise, you get the ludicrous position that they can raise money for the maintenance or for the sanitation or health purposes, but can't expend it for sanitation or health purposes, which is absurd.
right, so yeah, I was looking at section 21A. So 21A. So my thought was
20 brackets 1.
20, yeah, 20 brackets 1A, yes. Yeah, my thought is that the my Lord President is saying, well, you can just wrap all the power up within the direction under section 23. And my thought was that if you're going to use the money levied for a specific different purpose other than, my view is that section 23 is about the levying of the rates, and there are other specific sections that deal with the power to acquire and sell real property.
Selling real property is beside the point, isn't it? The various purposes for which the rates which have been levied may be applied are set out in section 23(1).
That's correct, yes. Yes, yeah.
And if one looks at paragraph 20, section 20, the corporations have power to purchase anything, really. And 1A requires that the sale of land to be approved by the legislature, but it doesn't actually require the purchase of chattels or land to be for municipal purposes.
Well, my Lord, that's where I think the rules of statutory interpretation that I've deferred to on more than one occasion come into question. If the minister were to use the money for a purpose that was other than a power or purpose that is within the Act, not only would that be challenged, no doubt, by the corporation, but it would be challenged even by the legislature. So I don't think that that is something that is a realistic prospect for it.
You're right that the power to purchase something, say a chattel, must be a power to do so for municipal purposes.
Yes.
Implicitly, the corporation can't have power to buy Fabergé eggs.
No. No more. So the next point I would like to make is this much vexed point about Section 1A and its enforceability. Now, my Lord, I believe paragraph 16 of our skeleton argument, that at 1:51 yesterday, I unceremoniously was cut off at the point that you were asking me a question.
Oh dear.
And that question, I believe, when I went back to have a look, was with respect to whether or not, if not independently enforceable, can the appellant simply rely on the common law to enforce the rule of law? Now, there are a number of authorities that my learned friend has relied upon within the UK context to explain the width and breadth of the rule of law as it's understood in an unwritten constitution. But with respect to the Bermuda Constitution, and indeed Caribbean and Commonwealth constitutions, that point has to be understood in the context of the authorities on the Caribbean constitutions. The starting point, and rather than go to it in great detail, I'll take you straight to the reference. The starting point is paragraph 48 of the skeleton submissions filed by the respondent on the 17th of September.
Yes.
So that is under the heading of the protection of law provision in section 1A of the Constitution, paragraph 47. Further to the preliminary points on construction in 6 to 8 above, Lord, and in paragraphs 6 to 8, we talk about the independent enforceability of the Constitution. On a proper construction of sections 1 to 15 of the Constitution, section 6, provisions to secure protection of law, is the subsequent provision that has effect for the purpose of affording protection of the rights and freedoms in paragraphs A to C, which include the protection of law provision in section 1A. This point was made clear in Matadine versus Pontu, in which the Privy Council considered the interplay between the protection of law in the fundamental rights and freedoms of the individual provision and the provisions to secure protection of law in the Mauritian Constitution, the equivalent of sections 1A and 6 of the Bermuda Constitution. Lord Hoffman says as follows: the construction to be given to the words protection of the law in section 3 must have regard to section 10, which is headed provisions to secure protection of the law, and is plainly intended, as section 3 says, to have effect for the purpose of affording protection to that right. Section 10 is concerned with procedural rights such as that of an accused person to a fair trial and a civil litigant to an impartial tribunal. It contains nothing to suggest that the Constitution uses the phrase the protection of law to mean a principle of substantive equality. Their lordships do not suggest that section 10 is necessarily exhaustive of the rights conferred by the words in section 3A. That would be contrary to the construction given to the section 3 by the Privy Council in Society United Docs, where Lord Templeman, giving the advice of the board, said that section 3 was not a mere preamble, but a freestanding enacting section which had to be given effect in accordance with its terms. But their lordships consider that Section 10 must throw light upon the question of what kind of rights are encompassed in the concept of protection of law. It would be surprising if those words in Section 3 had been used to mean rights of a radically different kind from those detailed in Section 10. So what we have, my lord, is we have rights of due process in Section 6 of our Constitution, Section 6 to 8 with respect to criminal proceedings, and Section 6(9) with respect to civil proceedings. We have, and this is some old ground, but it's the background to what we're going to submit. We have the cases of Thomas and Baptiste from the Trinidad and Tobago jurisdiction, which gave the equivalent of our Section 1A independent enforceability because their equivalent of Section 1 was independently enforceable. We have the case of Attorney General and Joseph, which is a Caribbean Court of Justice case, in which that court, under the judgment of Sir Dennis Byron, said that despite the fact that there was no independent enforceability, there would be a legitimate expectation, which would be the procedural right that would be guaranteed to allow that appellant to have the right to petition an international body. And in the middle, you have Lewis. You have Lewis, which is the case where there was no argument on the extension of our equivalent of Section 1A. And then you have Jamaicans for Justice. Now, the important point here is this. This is the conundrum. It's quite, if I say so for me, a tricky point. The way the appellants have presented their case is that they are saying, we want to claim a right under Section 1A with respect to 7AA of the Constitution. We say that it's against the rule of law. That's their 7AA claim. But if we can't come under 7AA, we want to rely on the common law. And they rely on Jamaicans for Justice for that. The problem with relying on Jamaicans for Justice is that Jamaicans for Justice was not a constitutional case. It was an application for judicial review. And in Jamaicans for Justice, not only did Lady Hale not say that she would rely on the Constitution, she specifically relied on the common law, and the common law was not challenging a statute. The common law was challenging the decision of the Public Service Commission refusing to reconsider the application of the superintendent for promotion because of the allegation of extrajudicial killings. And so a judicial review application applying common law rights could deem that decision procedurally irregular. Now, in our jurisdiction, the only method by which you can strike down or challenge a statute is either under Section 15 of the Constitution or under Section 29 of the Human Rights Act. So what they can't do is ride through the door saying that they're using Section 1A And when they don't, and if this court decides Section 1A is not enforceable, then just defer to the common law for a remedy which is only available under Section 15 or Section 29 of the Human Rights Act. Now, Lord, if I can take you, and this is the problem.
The Human Rights Act is you were talking about?
Well, Section 29 of the Human Rights Act allows the court to strike down or declare legislation void or invalid, as does Section 15 of the Constitution. But if you're using the common law remedies that are normally associated, and indeed, my Lord, Jamaicans for Justice, Attorney General and Boyce, and Thomas and Baptiste, and indeed, I believe, I stand to be corrected, Lewis, were all allegations of procedural irregularity by which a common law remedy could be used. Here, we're talking about using the common law. If the court says that Section 1A is not independently enforceable, are we going to use the common law to strike down or challenge legislation? There is no writ for that, we submit.
Okay.
If I can ask the court to look at the appellant's skeleton argument.
Duncan, can you help us? How much longer do you think you?
Not, Lord, I can not too much longer. I'm on paragraph 16, and I've only got 3 paragraphs left. I just want to explain this point, if I can. If I could ask the court to look at paragraph 109 of the appellant's skeleton argument. So Lord, at paragraph 109, the appellants contend that the notion of protection of law thus includes the rule of law. However, even if it is held that Section 1 of the Constitution is not directly enforceable, it is submitted as argued above at paragraph 65 to 70, the rule of law is in any event inherent in the structure of the Constitution. So that's how they put their case. So if this court says that Section 1 is not independently enforceable, we go to sections 65 to 70 to see how they then will ask this court to deal with Section 7AA. And you see that above paragraph 65 in that same skeleton argument, they rely on Nervas, and then they go in paragraph 65 to Lady Hale's judgment in paragraphs 23 and 24 of Jamaicans for Justice. And they say the learned judge advances a very narrow, paragraph 66, interpretation of her words, that's the Chief Justice, confining them to judicial review of official action and not of legislation, and suggesting...
Where are you reading from?
Paragraph 66, my Lord.
Of what?
Of the appellant's skeleton argument. So, my Lord, what happened is...
Moved from 109 to 66, have we?
Well, what he says, my Lord, if we go back to 109, this is very important because this is how they put their case. In 109, and I'll read it again, the appellants contend that the notion of protection of the law thus includes the rule of law. And these are the words. However, even if it is held that Section 1 of the Constitution is not directly enforceable, it is submitted as argued as above in 65 to 70. The rule of law is in any event inherent in the structure of the Constitution. So what they're saying is if you rule that Section 1 is not independently enforceable, they're going to go back and rely inherently on the Constitution, from whence I don't know, because the reality is it's either a challenge with the provisions of 2 to 14 under the Bill of Rights or not. Or what they're now saying is they're going to rely on the common law. And so they say, at paragraph 65, they then refer to Lady Hale's judgment. That's why I go to Jamaicans for Justice. But with respect, the learned judge significantly misconstrued Lady Hale's statements in paragraphs 23, 24 of the case. She starts in paragraph 23 by approving the words of Morrison J.A., who says that all—
Mr. Duncan, you've broken up for me.
Sorry, my lady, I'm leaning over where the case is. I'm going to put it right in front of the computer so that you can hear me. So she starts in paragraph 23 by approving the words of Morrison J.A., who says that all organs of state are enjoined to protect the fundamental rights of the Constitution. This surely includes legislature. May be the case, but how do they get a remedy for the specific relief they are seeking? They then say the learned judge advances a very narrow interpretation of her words by A, confining them to judicial review of official action and not of legislation, and B, suggesting that she reads the grounds of irrationality, unreasonableness, fundamental unfairness, and the arbitrary exercise of power as common law principles rather than constitutional rights. So the situation we have here is that they are asking this court to read these provisions as constitutional rights when there is no writ in the case to determine them as constitutional rights. Jamaicans for Justice did not say that that's what the decision was. And so when it comes to a remedy, this court is being asked to use common law principles, despite the fact that there are explicit statutory provisions that provide the right that they are seeking, but they cannot use them because they are not making a claim within sections 2 to 15, and they're not making a claim under the Human Rights Act.
Well, just a minute. We can't declare legislation void.
Or whatever relief that they are seeking, which is a declaration with respect to the legislation. I'm not sure how their summons puts it. I can go back to their summons as to how they actually put it. In their originating summons, which is at tab 1, they say, in order that the Municipalities Act and the other amendment acts, as well as the decision by the government to convert the corporation to a quango, as implemented by the bill, and the bill, if enacted, convene or would contravene sections 1 and 13 in that insofar as, and then they go on and they say, and to that extent, therefore, void and of no effect. Void and of no effect. So that's what they're asking this court to do. They're asking the court to use the common law to declare this legislation void and of no effect. And there is no Caribbean case on constitutional law that we have found where the common law has been used in that way to declare legislation void and of no effect, specifically when it's done in the context of a alleged constitutional infringement and not using the constitutional mechanism to do it. So, right. Lord, that sets out our submissions in paragraph 16 to 18. And then with respect to paragraph 19, we reiterate our submissions of paragraphs 31 and 32 of the rule of law submissions. If the appellant is correct on the rule of law point, the only possible remedy is a declaration in relation to section 7AA only, because that's the subject of the narrow appeal. You'll recall during an exchange I had with Sir Geoffrey, when he was discussing challenges to the legislation, I said to him, do you mean 7AA or the whole legislation? He said 7AA, and that's in fact what is in their skeleton argument at paragraph 111, footnote 50. Paragraph 111, footnote 50. The appellants contend that the provision in the 2018 Amendment Act fundamentally offends the rule of law. So that's what they're challenging. Paragraph 20, the reason the respondents have set out the presumptions and principles of statutory interpretation in such detail is because the starting point is for the Court of Appeal to read Section 7AA in conformity with the Constitution, if possible, rather than have the whole provision declared void and of no effect. And that's the Timberland case that we previously cited. As this point was not argued below, it remains unclear what remedy the appellant seeks with respect to that particular provision and applying the common law to that provision.
Right.
Lord, and if I can just quickly make a couple of points in relation to the freedom of expression argument. And then I will, I think, subject to instructions, conclude. First, looking at my learned friend's note that was provided to the court today, with respect to paragraph 3, my learned friend says the corporation is a local government entity which was run on democratic lines for about 300 years. That is not true. Up until 1978, only landowners could vote, and that excluded a large majority of this community, particularly the Black community. It was in 2010 that residents were entitled to vote. So this has not been a democratically run body. And I know my friend said with some minor problems. They weren't minor, they were major. And that's one of the reasons why this government wants to democratize the running of the corporation. Next, my lord, when it comes to the case of Toronto, can I ask the court to turn to that case? It is at tab 54F. Tab 54F. And my lord, my learned friend read the dissenting judgment. What he didn't read is what was held by the majority. Now, my lord, the first thing I'd like to do is ask the court to turn to paragraph 15 on page 14. Paragraph 15 on page 14. Freedom of expression is not, however, presently recognized as being without internal limits. Activities may well fall outside the scope of section 2B, where the method of activity itself, such as violence or the location of that activity, is not consistent with the charter provision. And you see that's under paragraph 14, which talks about principles of the charter. And you see this appeal hinges on the scope of section 2B of the charter, which provides that everyone has the fundamental freedoms of thought, belief, opinion, and expression. But let's turn, my lord, if we can, to, first of all, page 2. Page 2. Now we see
paragraph number.
Oh, I'm sorry, my lord. This is Okay, this is what was held, and actually it doesn't.
No, I see. Now I can find it now. Page 2, yes.
Yes, page 2. Now, if you look in the middle of the page, you see it says held, Abella and a number of other judges dissenting. So Abella, the judgment that was read to you, was the dissenting judgment.
Sir Geoffrey said that.
Sorry?
Sir Geoffrey said that.
Yes, I know. I was just introducing what I'm about to say.
Okay.
And then we have Per Wagner, who gave the judgment for the majority. And over the page, at the foot of page 3, this is what he says. As for section 3 of the Charter, it guarantees citizens the right to vote and run for office in provincial and federal elections, and includes a right to effective representation. The text of section 3 makes clear, however, that it does not extend to municipal elections. Effective representation is not a principle of section 2B of the Charter, freedom of expression, nor can the concept be imported wholesale into section 2B. Section 3 and its requirement of effective representation also cannot be made relevant to the current case by using the democratic principle. Section 3 democratic rights were not extended to candidates or electors to municipal councils. The absence of municipalities in the constitutional text is not a gap to be addressed judicially. Rather, it is a deliberate omission. The text of the Constitution makes clear that municipal institutions lack constitutional status, leaving no open question of constitutional interpretation to be addressed, and accordingly, no role to be played by the unwritten principles. So, my lord, it's our submission that when you add the Canadian Constitution reference, it addresses 2 points. One, my lord, it addresses your point with respect to no specific inclusion in section 9 of the right to vote. Secondly, it addresses the fact that municipalities are not considered to be part of the structure protected within the Constitution. And you'll recall, my lord, yesterday, I directed the court to the European Convention judgments, which were of the same point, the cases in Malta. This is a general proposition about the right of legislatures to legislate municipalities, and they not have the right to seek constitutional protection under a provision equivalent to the freedom of expression. So this is a part of the case that was not addressed. And so we say that in this case, there is no right to freedom of expression under our section 9. None of the, neither the European Convention nor the Canadian Constitution, they all make it abundantly clear the protection doesn't extend to municipalities.
Well, so there's no right of freedom of expression under section 9 in
Yes.
relation to voting in municipalities.
That's correct, my lord, yes. And that
Right.
reflects, sorry, my lord.
No, right, I said, I've understood
Yeah.
that.
Yeah, and that reflects the same as the authorities that I referred to from the European Convention. It's a basic proposition with respect to the primacy of legislation from parliaments with respect to regulating municipalities.
Right.
My lord, and I think that one small point with respect to paragraph 12 of their submissions, just a small point. My learned friend, Sir Geoffrey, said that the public order issue was raised by us. We didn't raise it. It was raised for us, despite the fact we knew nothing about it, in paragraph 149 of their submissions. In paragraph 149, they posit the public order exception for us. They were being gracious, I suppose, saying that they want to rely on this, and we will tell you which provision you can rely on as a defense, Lord, and we didn't posit that. So I wanted to make that point. And then the next point is with respect to the margin of appreciation. I'm not sure whether my learned friend did concede at the end that there was a margin of appreciation, which would have to be part of the exercise this court would go through in determining. Well, my Lord, the problem that my learned friend has is this, and I say this with the greatest respect. The Caribbean judgments all say that, and they, you start with the Freitas, we can go through all of them. I mean, I don't have them, but it is a standard principle that in seeking to determine whether or not, once the burden has shifted showing hindrance, and that burden is on the government to show reasonably required for one of the defenses, it's a matter, I say with respect, of common sense, that one of the things the court must do and the government must do is balance a number of factors, and the court then gives some latitude, some margin to the government. That's an exercise that takes place even in freedom of speech, because it's all contextual. It may be that the margin is lower in certain cases because of the nature of the importance of the particular speech. But what we submit is that there's no writ to say that there is no application of the margin ever in freedom of speech cases. And the final point I say is this, Lord, my learned friend responding to a request from Lord Justice Bell is going to identify certain passages within the evidence that respond to what is being purportedly stated as the kind of evidence we would have in response to a freedom of expression argument. My only point, which is a basic common law principle of public law, is that that can only make sense in the context of the question that was asked. If the government had been asked a specific question under section 9 to A to D, they would have given a specific answer. But to say that the government were not asked to provide a defense to the freedom of expression argument and then go and pluck evidence and say that that evidence somehow meets the notional defense without that specific question being asked.
That's not the way that it was put, but I don't think we need go into it.
Well, my Lord, I apologize if I mischaracterized what you said. What I am going to submit is...
What Mr. Myers said was that the best evidence was already in the record, and I asked for the reference for it.
Well, thank you, my Lord. My submission is this. It can't be the best evidence because you cannot arrogate to yourselves how the government would have answered this question. The question needed to be asked first and the government given an opportunity to answer it. So my submission is to now say, let's go and find some evidence and call it the best evidence.
Well, again, that's an unfair characterization. The point's been made. Let's move on.
Lord, as long as I've made the point, I need to make that point on instructions. That's
right.
my submission on that point.
Thank you very much.
Thank you.
Thank you. Right. Well, thank you all very much. Just before we leave, Mr. Jeffrey, I think it might be of assistance to us. I mentioned this at the beginning. If over the course of the next few days, you were to set out in terms the relief that you ask us to give. Assume that we are entirely in your favor. We want to know what the order would say. You're muted.
You're muted.
You're still muted.
So Jeffrey.
Sir Geoffrey, we cannot hear you because you are muted.
I think Mr. Myers has sent a message.
I have indeed, my lord.
My Lord President, while we're waiting for Sir Geoffrey to come off of mute, we have the parties here from the query case.
Yes.
Did you want to give them any timing directions?
Yes, in 45 minutes' time.
Okay, so Mr. Richardson, Mr. Daniels, you can leave the call now. We'll see you in 45 minutes.
Thank you.
Thank you all. Thank you.
Could perhaps Mr. Myers address this request from the president?
Certainly, my lady.
It doesn't seem to me to be that difficult a request to deal with. The
I
answer
think Sir
is
Geoffrey
yes,
has
of
got
course.
lost in cyberspace.
He has got lost. He's gone into cyberspace, I think.
I'm afraid so.
But
well-
Mr. Myers, is there any reason why your side shouldn't produce such a document?
We can do so, my lady.
Yeah.
But we'll do so.
That will be of assistance. It's got to be done at some stage.
And
Right.
Manuel, can I ask this question? We were going to make some submissions in reply on the aspects on control. I think Sir Geoffrey was planning to get there, but I mean, we do have a note. Can we send that in?
Right.
I don't understand this.
No,
Control has always been an issue.
Yes.
I can understand that people have had to make submissions when new stuff has come in, but this has been the central aspect. I'm surprised that it's now being sought to be put forward
No, no, it's
after
not.
the reply and after Mr. Duncan's reply to the reply.
Yeah, I would need to reply to that because I don't know what it is.
You wouldn't have a right, Mr. Duncan, to keep on replying,
No, but I don't know what he's
Take
doing.
it one reply at a time.
May I ask, am I back?
Yes,
You
you
are
are.
back.
Oh, thank you. I'm so sorry, but I've been rescued. Thank you very much indeed. My Lord, when I completed my submissions, I thought I'd completed my submissions on expression and was going then to proceed to control and property and section 1. However, as I have just heard, and we have a note on both, the one 5 pages, the other 9 pages. Now, these are both, I understand, replies.
Well, I know, but why, we've had your reply.
On section 1 and on control. We understood that we had made our initial submissions, and then Mr. Duncan had made his submissions, and it was open now for us to reply. We're very pleased at your instruction to forego oral reply, but it might be helpful simply to submit written replies. This is my question.
Well, yes, I just don't understand why it's being done at this stage.
Because I had not intended, and perhaps I said, I thought that I had not said when I completed my submissions on expression that these are the end of all our submissions. I thought I had said these are my submissions on the point of expression. And then I was going to proceed. Then you called on Mr. Duncan, and I was assumed that I would then be able to go on to a reply on the property and control issue and on the section 1 issue. But I'm very happy to simply submit those pages on it, and of course that would be our reply. I see it.
Right. Well, subject to the views of my colleagues, it seems to me you should submit them in writing.
Yes, we have them in writing. We can submit those right now.
Respectfully agreed.
Well, Lord, the only thing is I haven't seen them. And I haven't.
Well, no, but you, if they were given orally, you wouldn't have seen them.
Exactly.
Okay, my lord, if it just, anyway.
Right. Okay, well, thank you all very much. We shall now adjourn for 45 minutes before the next case.
My lord, are they going to be submitted now or when are we going to see them?
Right now,
Right now.
Mr. Duncan.
Well, and it, just for the record, I have no right to reply to any of that. I
They are
understand.
reply already.
Okay, well, my lord, I'm in your hands.
How many replies do you want?
We were at a tar now.
What?
Thank you. That concludes the hearing of this appeal.
He says how many replies.
Yeah,
Which
why
reply?
didn't you do your reply before?
Yeah, I don't understand.
Thank you. That concludes this appeal. The judges could retire to the breakout room and all the parties could leave.